and tradition meet. See you there.
Interested vendors should call 05.
Hello, very good morning to you. Welcome to The Big Issue. My name is Selorm Adonoo. The Big Issue is live on your screens every Saturday morning from 9 to 12 noon, and it's your platform for incisive analysis and riveting conversation where we put before you the key issues dissected and analyzed by very expert resource persons. So today we have two key issues on the table arising from matters that occurred in the week. Now, the Koforidua High Court, or High Court in Koforidua, presided over by His Lordship Justice Selorm Adonoo, has convicted the Member of Parliament for Akwatia for contempt of court. If you recall, on the night of the swearing-in of members of Parliament, there was an issue that arose on the Akwatia constituency. The NDC candidate for that election had gone to court and secured an interim injunction against the MP-elect at the time, and the court granted their prayer, and the court ordered that he should not hold himself out as MP-elect. He should not avail himself to be sworn in by the Speaker of Parliament as MP for Akwatia. And so the court directed that also to the Speaker. Fast forward, the day arose, he found his way into the House because the EC had gazetted his name, and so they got into the House. The Clerk of Parliament, who chaired that event that led to the election of the Speaker, raised the matter, put it to him, and he said, or his leader, it said through his leader, Fenny Markin, that he was ready to go through it. The clerk spelled out to him the consequences of the action, of he going through with it when a court of competent jurisdiction had injuncted him. They chose to go ahead with it and bear the consequences. Now, the NDC went back to court on contempt of court charges, raising those issues against him. Contempt of court in this matter refers to a situation where there is an order of the court, a person knows about that order and willingly disobeys that order. So the court deemed it as such. The court says that the MP in question knew about the order restraining him from holding himself up or availing himself to be sworn in as MP. He willingly disobeyed the order, and so he must face the consequences. So the consequences was that he was convicted for contempt of court. And once you're convicted, you have to be sentenced. But he was not in court to be sentenced. So the court issued a bench warrant for him. That is the situation we have now. He's since been in Parliament. In fact, on the day the pronouncement was made by the court, he left Parliament early. The following day he was in Parliament, he spoke, or he made a statement in Parliament. And just yesterday, he wanted to make another statement in Parliament. The majority said no, they will not condone that because the man is being convicted by a court of competent jurisdiction. There was a bench warrant for him, and they will not allow an illegality to be perpetrated in the people's house. The minority did not take it kindly. The minority also said they will retaliate, and that the way they prevented the gentleman from making a statement on the day the president delivers the state of the nation, they will retaliate. We don't know the form that retaliation will take, but certainly the minority is served notice. This morning, we want to examine the issues. The MPP is alleging judicial weaponization. Is that the case? What are the issues? What should a member of parliament do? What are the issues? Now that he has been convicted, often before you appear before the court, or when you appear before the court, you should show that you have purged yourself of that contempt. How does he purge himself of that contempt? Does he resign as MP? What does he do? We will examine all those matters today. The minority or the member of parliament has appealed the decision. A stay of execution is also being filed. That makes the matters quite complicated. But we'll deal with all of that today. We'll be assisted by seasoned lawyers to help us navigate our way through this legal maze. Also, this week, we saw some public sector salaries, wages increase, some 10% increase we saw. It was generally thought that the increase would have been higher given the economic situation we find ourselves. But guess what? The president himself was present at that meeting and he appealed to Labour, and Labour accepted the 10%. He promised that if things should get better by next year, the increment will be hefty. Labour accepted that and progress was made. It was announced as the new minimum wage, just 10%, which brings the minimum wage to 19.97 cedis per day, and monthly that'll be around 598 cedis, a little below 600 cedis. That should be the minimum wage. Nobody in Ghana should be paid below this. Of course, not enough, but are you satisfied with Labour's cooperation with government and the president's personal intervention in this matter? Also, government is promised to honor honoring DDEP payments. One was honored recently, and government says that it was able to do so because it reactivated the sinking fund. The MPP or the past government officials have said the NDC couldn't have done so alone. They did so because the government left behind some buffers. The NDC government, through its spokesperson and government communications minister, Felix Ofosu-Kwakye, has hit back swiftly, saying that there was nothing like that, and he showed to the public the movements in the sinking fund, from which payments were made. And he made a point that prior to the assumption of office, there was close to nothing in that account, and so everything that was done by the prudent management of the economy led by the NDC guys or finance minister and co. So taking full credit for that and trying to say that the past government did very little in that respect. We'll look at all of that in the bigger context of Mahama's economic interventions. Is it looking good? Are you happy with the signals you're seeing so far? What else should he do to ensure that the economy comes back on track quickly so we can see growth? So the show is live and interactive, and as always, you can join us via our WhatsApp number 0204447033, which is displayed on your screen. Also, you can join us on 0549986996. We are live on our socials. We are live on 97.3 City FM as well. Once again, my name is Selorm Adonoo. I'll take a short break, return, provide some updates, and then we'll begin the discussion. Don't go away. You're welcome back. This is the big issue, 97.3 City FM and on Channel 1 television, on our socials as well. Do well to join the discussion. We want to hear from you, on what you think. Two key issues. The High Court in Koforidua has convicted MP for Akwetia and Eskumi for contempt of court. The MPP is alleging what they call judicial weaponization. And the NDC in Parliament, the majority in Parliament yesterday prevented a gentleman who is wanted by the court because a bench warrant has been issued for him from making a statement. The minority was not happy. They said they will retaliate. We are yet to know or see the form that retaliation will take. In the meantime, they've filed an appeal. We were told by the Deputy Minority Chief Whip that an appeal has been filed. Together with the appeal, a stay of execution motion or application has also been filed, which essentially means that the execution of that judgment or decision or ruling by the court be stayed until the appeal, until the substantive application for the stay is heard. It may be granted or not, and then other things continue from there. So we are looking at that. We will look at that this morning. Also, government is honored DDEP payments. Government has raised public sector salaries or wages by 10%. Many people think it's inadequate, but the president intervened specially and Labour cooperated. President is promised that next year things will be better, and that once things are better, the wages will go up by more heftier percentages or increments. We are looking generally at Mohammed's economic interventions. Are you happy about what you're seeing so far? Is there anything he has to do? Is he saying the right things? Is he doing the right things? We'll look at all of that a bit later. But from yesterday in Parliament, the second deputy speaker, Andrew Esiamamwako, had to adjourn parliamentary proceedings to Tuesday, February 25, 2025, due to a disagreement between the majority and minority caucuses. The controversy arose when the majority caucus objected to a statement by the MP for Akwetia, Ernest Yakumi, on the floor of Parliament. The reason for their objection was Kumi's conviction for contempt by the Kufuria High Court and the issuance of a bench warrant for his arrest. Channel 1 News' Nia Ayikoka, parliamentary correspondent, was there, and he reports.
On January 6, lawyers for Henry Boakye, the National Democratic Congress NDC parliamentary candidate for Akwetia, secured an interim injunction against Ernest Kumi. The order prohibited Kumi from taking the oath of office as the MP-elect. Despite the ruling, Ernest Kumi was seen on television later that day in Parliament being sworn in. This led Henry Boakye's legal team, led by Bernard Bedia Kumbeidu, to file a contempt case against him. During the hearing, the presiding judge, Justice Selorm Adonoo, noted that Kumi failed to appear in person throughout the proceedings. He also rejected a letter from the Parliamentary Minority Caucus, which claimed Kumi's absence was due to official duties. The judge stated that accepting such a letter would contradict his own ruling. Justice Amedehe concluded that available evidence proved Ernest Kumi wrongfully defied the court's order by going ahead with a swearing-in. Counsel for Henry Boakye, Bernard Bedia Kumbeidu, spoke to the media after the proceedings.
It is a bit shocking, and we lawyers don't usually critique one another or each other. I mean, because we have been trained not to. But I'm a bit surprised that Mr. Gary Nimakun would rise in open court in a contempt case, which we all know, we've all been trained and are aware that contempt proceedings are different from, because the standard of proof is even different. It has a different case number.
Expressing his dismay at the conduct of Ernest Kumi's lawyer, Gary Nimakumafo, Mr. Bedia Kumbeidu criticized his disregard for legal procedures. He further assured that all necessary steps would be taken to ensure Kumi's arrest and compliance with the law.
Indeed, all the ingredients in all the authorities he listed proved that he willfully disobeyed the orders of the court, and that irrespective of your opinion about an order of a court, it doesn't give you the license to disobey it until it is set aside. No court, as we speak, has set aside or did set aside the interim injunction. And so he was completely out of order to disobey the orders of the court. And so the court said that when that happens, the law is clear. You need to be convicted and sentenced. And so the court today convicted him. That is, the procedure is that, you see, the court cannot give his sentence in a vacuum. So the court at this point has found him guilty. That's the meaning of the conviction. When the court says that you are convicted, it means that you are guilty of the offense. Now, because he was not in court, the court now says that he now issues a bench warrant like any other criminal. And the police, the national security, should go after him wherever he is.
Lead counsel for Ernest Kumi, Gary Nimakumafo, declined to comment after the proceedings.
Wednesday, the Koforidua High Court convicted Akwetia MP Ernest Kumi for contempt after he defied an interim injunction barring him from being sworn in as a legislator. A bench warrant was subsequently issued for his arrest after he failed to appear before the court for sentencing. That notwithstanding, the MP has since been attending two parliamentary proceedings. In an attempt to deliver a statement on the floor of Parliament on Friday, the majority leader, Mahama Yariga, stated that the caucus would be compelled to stage a walkout on what they describe as an illegality if the MP is allowed to present the statement. This generated a heated debate on the floor, compelling the second Deputy Speaker, Andrew Esiama-Amoako, to adjourn proceedings to Tuesday, February 25, 2025.
We caution him in this house. We said, look, there is a court order restraining you from being sworn in. If you refuse and you allow us to swear you in, you will be held accountable. And he said, yes, he's ready to be held accountable. Now he has been held accountable by the courts, and he wants to come and use this parliament as a shield. Mr. Speaker, it won't happen. This side will not allow that. We will not allow him to make the statement on this floor, because he has been convicted by the courts. At least he should go and file an appeal. He should file an appeal. He should seek to state the execution of the orders of the court. Then we know that due process is being complied with. Mr. Speaker, I want to indicate clearly that if you insist and admit this statement and you allow him to make the statement, this side of the house will wash our hands off and then we'll walk out and leave you to make your statement. Order 25, Rule 5 says that failure of the registrar to inform the Speaker constitutes contempt of Parliament. Mr. Speaker, it may seem that the majority leader is bringing to your attention contempt of Parliament by the registrar of the court. If there is any such conviction, is that what the majority leader is doing before the court? Venerable majority leader, distinguished majority leader, is it that you are bringing to the attention of the court contempt of court by the registrar of the court? Or are you now the registrar? Very respectfully, Mr. Speaker, in the circumstance of this, Mr. Speaker, this parliament cannot trade in ake to disenfranchise or disallow a member of this house from performing his legislative duty. The majority leader knows that he was only doing politics and not doing law. He knows that what he did was politics and not law. Mr. Speaker, in this house, how can a member of parliament who in the performance of his parliamentary duties has not been served with the court process? Mr. Speaker, let them sit quietly and listen. Let me finish my submission. Mr. Speaker, if they want, then you talk. What? Yes. Well, let's go right. Mr. Speaker, it is clear that the NDC side, when they talk, they don't want anybody also to have an opportunity. It was started by you. I am responding to your argument. Why? We cannot respond to you.
Let me listen to you.
Mr. Speaker, he has to finish. He has to listen to me. I'll come to the point of the parliament.
Honorable,
your application you are
the
right
time
now
is 5 to 4 o'clock. You are in my hands. The house is accordingly adjourned.
There are other matters of social justice in the country that perhaps they have overlooked. So if they are showing us the path of social justice and the rule of law, we have heard them. From Tuesday, we, the minority, God willing, will also begin the process of bringing to the fore all the issues that the government must undertake to bring social justice in our country. And we will not limit it to Tuesday. We'll go on Wednesday, go on Thursday, Friday, and we'll continue until all the issues of social justice are addressed. So we thank them for forcing an adjournment today. We thank the NDC majority caucus. We thank them. These are useful lessons.
Whereas the minority believes that the 10% increase in the salaries of public sector workers is woefully inadequate compared to what was witnessed under the Akufo-Addo government.
All right, so that was Nia Ikuyokan bringing to us what happened in Parliament yesterday. And earlier you heard my colleague Niyama Kanaku, who is our Eastern Regional correspondent. He was in court in Koforidua the day the MP was convicted. So this morning, we have an interesting discussion before us. My guests are Inusa Fuseni, the Honorable, former MP for Tamale Central, former Minister of many portfolios, Nana Eje Bafo Ewa, MP for Menchia South, Bobby Banson, private legal practitioner, and Franklin Kujo, President Imani Africa. These are my guests this morning. Good morning, gentlemen.
Good morning. Good morning.
Honorable Inusa Fuseni, it's been great seeing you again. Interesting scenes in Parliament.
Yes.
Majority forcing an adjournment. Normally, it should be the minority doing this, but majority is forcing an adjournment now. What are your thoughts around the issues about the conviction of the MP and the matters arising?
Well, thank you so very much for having me, Selorm. Indeed, the conviction of the honorable member for Akwatia, I say honorable member for Akwatia because on the 7th day of January 2025, he was sworn in as a member of parliament. I ought not to have addressed him so if he had respected the orders of the court. And so the matters were very clear. A matter was pending before the High Court of Koforidua, in which the election of the member of parliament for Akwatia was challenged. The petitioner had brought a motion to court for a temporary restraining order to prevent him from holding himself out as a member of parliament. The order was granted. The court restrained the member of parliament from holding himself out as a member of parliament elect for the Akwatia constituency. Keenly aware or acutely aware of the existence of the order of the court, the MP presented himself to parliament for him to be sworn in. Now, the matter was raised on the floor of the House that there was a temporary restraining order against him holding himself out as a member of parliament. The minority leader intervened on behalf of the member of parliament and said he was prepared to bear the consequences of being sworn in as a member of parliament. Now the matters have come to a head. He's bearing the consequences. He's carrying the cross because he had elected to carry the cross. Now, so I simply do not see how anybody can say that there is some level of weaponization of the courts against that member of parliament. Because his act was willful, was deliberate. He knew exactly the consequences that would befall him. He went ahead with impunity and decided to be sworn in as a member of parliament. And that is what we are faced with. I don't know how he's going to purge himself of that contemptuous act. Because in the face of a clear, and the rules are clear, where there is an injunction, there must be an injunction, an order of the court injuncting you. That injunction must be clear on the face of the order. The injunction must be executable.
It must be brought to your notice.
It must be brought to your notice. Yeah. So I don't know how he's going to purge himself of the contemptuous act. I thought that the majority leader would have simply advised him to go to court, to find a way either to set aside the temporary restraining order or challenge the basis upon
I think he did say that in the end that he should either appeal or file a stay. Then they will know that there's due process, in motion.
Yes.
And they have since done that actually. On the day, Gary Macron filed a stay of execution. Subsequently, we understand that a notice of appeal was filed. together with stay of execution.
But the fact that the processes have been filed does not operate to obviate the reach of the temporary order.
So I think what they're trying to fight is the conviction. So once a stay has been filed, until the stay is heard and determined, it operates as a stay actually. So that's what they are seeking to do. The stay, the return date for the stay, I think is later in the month. That stay is before the judge himself. We don't know whether the judge will
grant them the stay,
grant it or dismiss it. But I mean, I don't know. But there's a way it works in practice. But I won't say so. So if he dismisses it, they may have to go up. That may take time and all of that. So it's interesting how that will play out. But you think he was misled on the day because it doesn't appear there was so much at stake. The numbers were not close. The numbers were not like what happened in the previous parliament where you had 137, and so even a member could make a difference. This one, the difference was huge, about 100, seats in between them. You think he was misled into staying in and getting sworn in and now facing the consequences?
I think whatever happened, he never looked at the consequences of his actions very carefully.
But I understand he's a lawyer.
Well, of how many years practice? Of how many years practice? I mean, clearly, if you go to court, and the court has reasons to grant you a relief, and you intend to implement or execute the relief, and especially if the court is said to have said that he should not do certain things, restraining him, prohibiting him from doing and engaging in certain things, and you openly, deliberately go against the tenor of the order, you are setting yourself up against the court. And as you know this, I mean, until the prohibitory order was set aside, it was supposed to be meant to be obeyed. And you cannot just treat a court order with contempt. You're going to court, that very court, for justice. You claim you have been validly elected. The matter is pending before that court. And you have decided to treat that court with contempt. I mean, I don't know who advised him. If he was advised at all, I thought the best thing was to temporarily remove himself from parliament, from being sworn in, go fight the case, go remove the restraining order, and come to a sworn in. I mean,
he would have been in contempt already because the order was prohibiting him from availing himself to be sworn in.
Holding himself up. I mean,
yes,
he was not. If you are going around town saying that you have been elected member of parliament, that is nothing.
Yeah, the but the order said he should not avail himself to be sworn in.
Yes,
and he has been sworn.
So availing yourself to be sworn in is holding yourself out as MP. That's it. I mean, that's so clear. That's so manifest on the face of the act. And so that is what I'm saying. He ought not to have gone there at all. Just go fight, have the order set aside, and then. I mean, there are many ways that there are many ways that you can do these things. And there are authorities, except that the recent Supreme Court authorities which seem to suggest that a person should not be restrained from representing his people in parliament. I mean, so clearly there are authorities. I thought that they should have just exercised patience and gone back to the court, fight the restraining order, get it removed from his head, and come. I mean, after all, the case is in court. This is an interim.
The interim order was just for 10 days.
10 days,
and then you come on notice. And then you make a case about representation of the people and
all those things,
citing the Supreme Court decisions and all of that. And
you see why I fail to understand the import and of the actions he took, or probably he did not appreciate the severity of the consequences of the actions he was taking and the seriousness of those actions. Because, I mean, 10 days, interim injunction, 10 days.
Anyway, let me speak to Bobby Bansin. Bobby is a private legal practitioner. He deals with such matters every day. Let's see what he says about this. Bobby, good morning. Welcome to the program. Were you surprised to hear that the court had convicted or held the MP for Akwetia in contempt of court following from his decision to get himself sworn in by the Speaker of Parliament. Were you surprised by that decision?
Good morning, fellow. Good morning to very learned senior at the bar who just spoke before me, Honorable Inusa Fuseni. Selorm, I don't deal with such matters every day. I don't have the privilege of representing clients fight contempt of court in this nature, but
my apologies there.
I'll try and speak generally to the issues. So it's been an interesting development over time, particularly in the context of the processes that were filed prior to the committal for contempt. Your colleague shared with me all the processes that had been filed, and I've gone through them. One, we can't dispute the fact that there was an ex parte order for interim. Mia Fuseni said it means that you would have to now repeat the application on notice. That ex parte order for interim injunction was served on the Member of Parliament, Mr. Kumi. One would say that once it's been served on him, then he has to respect it until another decision is given by the court. Or, you know, the practice that lawyers do, when you file you obtain the interim order for injunction ex parte for 10 days, then you'd have to repeat it. And as long as the repeat application is pending, then it means then that the person who was restrained by the 10 days will still have to be restrained until the repeat application is heard. It was interesting that such a very sensitive order relating to representation of or a person or a constituency would have been made ex parte. If I was exercising the discretion, I would have asked that it should have been on notice. But the moment you file and serve on notice, it would have the same effect that you would have gone with ex parte order. But to apply and obtain an ex parte order for someone to stop holding himself out as a Member of Parliament when the Electoral Commission has declared him, it may set a bad precedent because the judge would have made such a very important decision with only one side of the story. But that has been done. It's gone. When the interim order was served, I have seen processes where the counsel for the Member of Parliament declared, let me describe him that, or just let me describe him as the respondent, filed, I think, 2 or 3 processes after that. I have seen the application for certiorari to quash the order. I have seen the applications for stay of proceedings. I even saw an application to arrest the delivery of the ruling or the contempt or something like that. Generally, we know that an application for stay of proceedings pending appeal does not have the effect of restraining the judge from hearing the matter. The Supreme Court has decided that.
But it has the effect of staying the execution of the order if the order has been made already.
I spoke about the stay of proceedings.
Okay, stay of proceeding. Okay, I get it. Not stay of execution.
Yes, okay. The stay of proceeding.
Sure.
Because they filed an application for stay of before the contempt ruling was delivered. After they were served with the interim order, they proceeded to file a certiorari in the Supreme Court. Then they filed an application for stay of proceedings.
Okay.
Yes, so that the contempt proceedings itself will be stayed. And then they filed an application to arrest the delivery of the contempt ruling. So those are the 3 applications they filed before the ruling was delivered. And I'm saying we all know that from our jurisprudence, the Supreme Court has said that an application for stay of proceedings does not restrain the judge from continuing hearing the matter. It is at the discretion of the judge whether he or she thinks that looking at the circumstances and your attention has been brought to this, you will indeed restrain yourself until the stay of proceedings is determined. So you cannot fault the judge from continuing to hear the application for contempt when the stay of proceedings was held. However, there was another application for certiorari. Certiorari, and I'm not going into the merits, but we know that certiorari essentially means that the judge didn't have jurisdiction or went beyond jurisdiction. And if you hear or committed an error within jurisdiction, patent on the face of the record. If you read the affidavit in support, they are saying that the jurisdiction to entertain petition against parliamentary election should be filed within 21 days from the date of the Gazette. And from all evidence before them, the Gazette was done on the 6th of January, which was before the interim order was made. And so the court's jurisdiction had not been properly invoked. So they've gone to the Supreme Court for certiorari. But we know that as for certiorari, once the judge's attention has been brought to it, you are required not to proceed on the matter, unlike stay of proceedings, because certiorari is challenging your jurisdiction. And once your jurisdiction has been challenged, the position of the Supreme Court is that it automatically serves as a stay of whatever you are doing before you. Now, the documents that have been filed by the respondent indicates that their searches, and again, we are not speaking to the merits. We are speaking generally. Their searches show that at the time that the proceedings for the contempt were held or were heard by the judge's attention had been brought to the certiorari application pending at the Supreme Court, that it was on the judge's docket before he allowed the counsel for the applicant to move the application. And if that is so, then there may be a jurisdictional issue over there. Now, the second thing is that they had filed an application for arrest of ruling. Unfortunately, the jurisprudence here is that an application for arrest of ruling is, as Justice Chebafo will call it, anachronistic. He has a term, I don't know, Selorm, if you've heard him use that word. The courts have now said that there's nothing like an application for arrest of ruling. And so the three applications that were filed before the judge delivered the ruling, I would say that looking generally, two of them would not have operated to restrain the judge from proceeding to hear the contempt. But I think the certiorari has the impact of restraining the judge from hearing the contempt. The judge went ahead to hear. But the more interesting thing for me is that, Selorm, you know that in the current dispensation of CI 47, before a judge's jurisdiction is invoked to commit a respondent for contempt of court for disobeying an order of a court. So, you know, contempt could be contempt in the face of the court. That is, you've said something or you've done something that the judges find insulting or disparaging to the delivery of justice. That is contempt in the face of the court. But the second form of contempt is if you have disobeyed the court order after the order has been served on you. Now, that leg, which is the basis of the respondent being committed for contempt of court, the current dispensation says that a judge's jurisdiction cannot be invoked unless the person that has been cited for contempt is not only served with the order that you are saying the person has disobeyed, but also must be served with what is called a penal notice. So Order 43 Rule 7 says that if the penal notice is not served, then the judge does not have jurisdiction to commit that person for contempt. What is the penal notice? The penal notice is informing the respondent that you've been served with this order. We have seen that you are disobeying it. And it's like we are giving you a warning that if you continue to disobey it, then we would, cite you for contempt. The reason why I believe the Rules of Court Committee brought in this penal notice is just to remind people the consequences of disobeying a court order. And the Supreme Court has held that if this penal notice is not served, then the court does not have jurisdiction to commit that person for contempt of court for disobeying the order of a court. Now, the processes that I have read, I have not seen the evidence that the penal notice was served. And so if indeed it was not served, then that could be another basis for saying that the judge did not have the jurisdiction to commit the respondent for contempt of court. So those are my appreciation of the facts and the evidence as was shared with me by your team.
That's quite interesting. What happens then? Because at the time he committed the offense, of course, he was injuncted. And so your point is that the penal notice should have been served within the period between when he breached the order and when the contempt application was brought. Is that correct?
No, before the
No, when the committal was made.
When the committal was
So-
made.
Yeah.
Yes, when the judge actually found him, before the judge could have read in court that I hereby find you having acted in breach of the order and sentence you or convict you for contempt of court, the judge must satisfy himself that the respondent was served with the penal notice.
Okay, so in this instance, there is nothing on the record showing that any penal notice was served on the respondent.
From the processes that was shared with me by your colleagues, there is nothing on the no mention of it at all.
That's quite an interesting one. I don't know what so the way forward will be really. Of course, an appeal is being filed, certiorari is being filed, stay and all of that is being filed. And you've also been following the deliberations in Parliament. The majority says that they will not allow him to make a statement until he does 1, 2, 3 things. The notice of appeal is one of them. The stay of execution is one of them. Now that we have information that those have been done, then it means that we treat it as if nothing has happened, correct?
I don't think we should treat it as if nothing has happened.
Until the applications are heard.
Yes, because we know that even if a judge makes an order that is not valid,
it has to be obeyed.
Yeah.
Until it's set
it has
aside.
to be obeyed.
Yeah.
And so the order asking him to appear before the court, I have seen the application for stay of execution. So if that is pending, then it means that no further steps can be taken in respect of that. But at least out of respect for the court, I expect that him and his lawyers would appear on the next date and then inform the court that, listen, we have filed an application for stay of execution. So can you then, adjourn the proceedings until that stay of execution is heard? As you have said, I do not think that Parliament would prevent him from carrying out his duties until that stay of execution application has been heard. If it is dismissed by the High Court, which the High Court would have the jurisdiction to dismiss, their recourse is to repeat the application at the Court of Appeal as we know it, and then see the outcome of the Court of Appeal. But like I said, I think that they would have to appear before the same High Court judge and then make the case for why the contempt, the conviction. So he's been sentenced, awaiting conviction. Why the conviction should be put adjourned.
He's been convicted, awaiting sentencing.
Yes, so sorry. Yes, he's been convicted, awaiting sentencing. So why the sentencing should be adjourned until the determination of the various applications that have been met, they must appear. My only challenge with this narration is, once we start saying that the judiciary is being used as a weapon, I've always said it doesn't matter which political side is saying it. We must always stick to the law and the facts and the evidence. Because the moment you introduce politicization of the issues that have been determined, you take away the public confidence in the judiciary. And my position has always been that political cases do not make up. Selorm, I see you in court every day. I don't think that you go there to do cases relating to politically exposed persons. Political cases involving politically exposed persons do not make up even 2% of the cases that are heard. But the moment politicians say that the judiciary is being used to as a weapon, then the man on the streets who is dependent on the judiciary against somebody else who will now say, no, if I have a matter, I need to see a politician to go and influence. That aspect, that narrative that politicians at the slightest opportunity tend to spin decisions of their judges and always make up political capital out of it is something that, as much as possible, we should discourage.
I see.
Discourage.
Interesting thoughts there from Bobby. Honorable Inus Afuseni, I mean, a number of things he has said. So certiorari has been filed. If that has been filed, then that is a difficulty for the judge. He said he has not seen any penal notice. I've not seen that too. If that was not done, clearly that's a concern for the judge going ahead to convict the MP of contempt for court. What are your thoughts around this?
Well, I mean, you see, in listening to Bobby Benson, I still cannot wrap my head around why he did what he did. Because even on the face of what he said, there were enough grounds for you to go to court to vacate the order. There were enough grounds. I mean, if you are raising the matter of jurisdiction, and jurisdiction, we all know, and the Republic. Is that concerned with the merits? It's not. Was his jurisdiction properly invoked? Did the court have jurisdiction
at the time?
At the time. If it is your view that he didn't have jurisdiction, go to court. File to vacate the order on the basis of lack of jurisdiction. And the court will, if the court is convinced that your application has merit, it will vacate its own order. And you could do that within even the 10 days. You didn't need to wait for them to repeat the application on notice. And with the other two matters that he has cited, granted that that's the case, the order still remains in force until
it's set aside.
Set aside.
I see. Interesting. This is the big issue. 97.3 City FM and on Channel 1 television. We are debating, or we are discussing or dissecting the conviction of the Akwatia MP for contempt of court. Some matters have arisen. Some applications were filed prior to the delivery of the ruling, and we are looking at the implications of all of those matters. My guest this morning, Inus Afuseni, former MP, Tamale Central, Bobby Banson, private legal practitioner, Franklin Kujo, and Nana J. Bafo will join us pretty shortly. So we see their sides of we look at their side of the matters. Bobby, so the gentleman in question, he is in all of this. If you are advising him, maybe at the beginning, would you have thought, or would you have said, or advised that he went ahead to get sworn in, or you tell him to wait so that the processes, are exhausted fully before, he gets into parliament? In any case, many have said there was really nothing at stake. The numbers were not close. There were about 100 seats in between, so there was no way his singular presence on the day was going to make any difference anyway. In any case, the election of the speaker, which was the contentious matter the last time, was not an issue this time because there was no contest. There was no other person put forward by the minority.
There are a few people that you really want to advise as a lawyer. A politician and somebody who is in love. So, because their considerations are not always aligned with law. They look at what they say, my people have elected me, I must show up. And that, for them, trumps any other consideration. I will not say that what he did, showing up, if at the time he showed up, the certiorari had been filed, whether it is completely illegal or whether it is avoidable. So the question you could say, whether if he had avoided it, what would he have lost? He wouldn't have lost anything, because if he had not been sworn in, it would not have affected the fact that if he says that he had been elected, eventually the orders that had been made by the court would have been set aside anyway. Now he has decided to go ahead. All these scandals, if I may put it that way, have come up. He still has to deal with it, and so would be something that would have to consider whether, with hindsight, he could have avoided it or not avoided it. But like what Senior Fuseni said, it's not too late. He can still undo what has been done if the processes as have been filed by his counsel. Actually, the affidavits and the issue of the penal notice are matters that actually have evidence before the court back in it. So if as it stands now, I think that going forward, at least on the next day, to avoid the further embarrassment, because once the bench warrant has been issued, it must be executed. And so to avoid all of that, he can just voluntarily appear before the court with his counsel, raise the evidence of the processes that have been filed. And I want to think that the judge, if he is minded, seeing the processes that have been filed, because the conviction is already on the record. It's not been set aside yet. What is left with is the sentencing. So if the judge would deal with the document that are before him, I want to expect that he would adjourn the sentencing until all the other applications have been filed, and then we would see how to proceed from there.
So the stay of execution which has been filed does not affect the bench warrant. Is that it? Because you said once the bench warrant is issued, it must be executed. But we know they filed a stay of execution.
Yes. No, what I mean is that the lawyers would definitely have to appear before the court with the respondent.
So between now and then, if
I don't know when it was adjourned to.
It was, I think,
so, for example,
I think the return date on their stay application is around 28th February, if my memory serves me right. I don't know when the matter was.
But I don't know if
yes.
I don't know if at the time the judge issued the bench warrant, he adjourned it to another day for sentencing.
So what I heard from the lawyer on the day was that the Chief Justice is giving a warrant for the matter to be heard every day. So it does appear they appear before the court on daily basis. If
daily basis.
Yes. So any day he's seen and is brought to court, I'm sure we'll do.
And if it were me, I would appear before the court with my counsel on the next day and inform them that I have filed a stay of execution, which is adjourned to 28th. So,
I see.
So it will come back on the 28th. That way, it lightens up the issue of the bench warrant because now you have appeared and you have said that you would come back on the 28th to deal with your stay of execution, which is just next week Friday, I think.
Yeah. So as it stands now, is the bench warrant still executable, or the bench warrant is held in abeyance by the stay?
Yes, it has to be. It has to be held in abeyance until the stay is heard.
I see.
Yes, but I only said that out of respect for the court, just to prevent the seeming acrimony between the parties and the court.
But it does appear that a position has been taken. If you listen to Jerry Shaib yesterday, I mean, it does appear a position has been taken against the court. They are fighting it, and so the position and the language being used appears quite antagonistic. I mean, you know, so to appear before the court, I'm sure when they appear, they will want to fight it and fight it with all the strength they have. So maybe they may appear on the 28th. For now, a stay is being filed. He's in Parliament and all of that. So until 28th, I'm not sure anything will happen. Of course, a lot of things could change, but I'm just judging from the language being used, from their press statements, etc.
Well, it's completely within their rights. They will not do anything wrong if they don't appear until the 28th. But I don't believe in antagonizing the bench. You may disagree with their decision. That is why there are opportunities to either appeal or invoke the supervisory jurisdiction of the Supreme Court. And then we would see how it turns out.
I see. So, I mean, they could appear any day. Bobby's just saying that it doesn't. They don't do anything wrong by not appearing once a stay has been filed. What's your thoughts as well? You think they should appear, or they should wait to the 28th?
So you see, because we are lawyers, we must talk to the facts and see what is likely to happen. A bench warrant has been issued.
Yeah.
The bench warrant has asked for the arrest of the Akwatia MP, the embattled MP. The court warrant is now with the the officers who have to execute it. Now, even if they are aware that because there are pending processes in court, the embattled MP and his lawyers have some days to appear, they might want to embarrass him.
And say they don't know about it. They've not been served.
Yeah, but they're not judges.
Yes.
So you see, if I were a lawyer to him, I would advise him to appear in court the next day. Now, which is Monday. Okay? And draw the court's attention to the pendency of these matters. And if you are even compelled to move applications that are already before the court, move them that day. Okay? Or pray the court for an adjournment to move them on the next return date. And then, at least, that the embattled MP can be safe and secured, that nobody will embarrass him when he's in his car going home. And we must all get that.
But can they arrest him when he's on his car going home from Parliament, giving the immunities of an MP?
They're saying that he should not hold.
He's not as an MP.
You're assuming that they are recognizing him as an MP.
So they are not recognizing him.
They're not recognizing. The court is not recognizing him as an MP.
So he can't be accorded those courtesies.
And so go to court simply and have the proper things done. And you see, I don't know. I mean, and I agree with him. I've always said that for the courts, we have all been there. I mean, the idiosyncrasies of the judge. You go to court and then you move an application, the court grants you the application. But that doesn't mean that's the end. Okay, the court's order can be set aside. And that's why we have layers. And in fact, in the court system, there's wisdom, even in numbers. So if you at a high court, you are not satisfied, you go to the Court of Appeal, you have 3 judges. Okay, and there's a Supreme Court, you have at least 7 judges, or 9, or 11, or so you just have to exhaust the processes of the courts. And I will not advise any politician to take the powers of the court lightly. I mean, you might disagree with them, but they can deal with you. And they deal with you on the basis of facts that are before them, their understanding and application of the law, and how they relate to you. And so, if the court somehow comes to the conclusion that the facts that were before him in Kofredua, touching and concerning the elections of the Akwatia MP, are facts that warrant that a stay be granted, and we did that, he simply would have limited the injunctions to a number of days. And even the recent Supreme Court case where an injunction was granted almost in perpetuity. You remember?
Which on which matter?
On the dismissed 3.
Oh, the recent matter, the 3 MPs who were deemed to have vacated their seats.
So clearly, we are now in a jurisprudence that clearly should tell you that in matters of this nature, you have to attach the most serious of attentions to it, because your personal liberty is at stake, and your rights as an individual could be compromised.
I see. This is the big issue, 97.3 City FM. We'll take a short break. When we come back, we'll look at what could possibly happen. Of course, not to get into the merits of the case, but look at scenarios here and there. We'll be right back with more. Don't go away.
All is set to explore 14 amazing regions of Ghana on the Heritage Caravan 2025.
If you want to come to Basu, see the dancing and write your name.
Dive deep into the rich Ghanaian culture through the food, the music, the history, and the captivating traditions. From the 2nd to the 9th of March 2025, you will experience the road trip of a lifetime. Build connections, network, and share unforgettable memories with fellow adventurers.
You have done half of the way. You have half more to go. How are you feeling? How are you feeling? Okay, I'll never do this again.
So this is a grand entry into the water for a hot afternoon bath.
The Heritage Caravan will smoothly drive through the Greater Accra region, Eastern, Volta, Uchi, Northeast, Upper East, Northern, Savannah, Bono East, Ahafo, Ashanti, Western North, Western and Central regions. Throughout the 8 days on the road, groove to authentic live band music on the wheels with the melodic In Chim Chim Band. The Heritage Caravan 2025 will be fun, educative, refreshing, and most of all, remarkable. Stay updated. Follow all Channel 1 TV and 97.3 City FM social media handles for updates and join the conversation with the hashtag Heritage Caravan 2025. The Heritage Caravan 2025 is powered by Channel 1 TV in partnership with the Ghana Tourism Authority, with support from 97.3 City FM, and proudly sponsored by the National Lottery Authority, Hollard Insurance, Omni Basic Bank, Goyle PLC, GB Foods, Standard Water, Apollonia City, and Beaver Beverages. Terms and conditions apply.
Yeah, welcome back. This is the big issue, 97.3 City FM. We're also live on Channel 1 television, on our socials. We're happy to hear from you. The text lines are 020-444-7033 as displayed on your screen, or 0549-986-996. We're looking at the issue of the conviction of the Akwetia MP. The MPP is alleging judicial weaponization. We're trying to look at the issues, and interesting matters have arisen. The fact that there's a certiorari which was filed, a stay of execution is also being filed, and these once they are filed, stay a number of things. The stay of execution may stay the execution of the order, so there's a bench warrant issued that may stay it. There was a certiorari, we understand, was filed earlier that ordinarily should have made the court want to look at it properly to await the outcome of that certiorari application. But be that as it may, a conviction has been made, and as it stands now, that becomes the valid order of the court. And as the authorities have said, once the order has been made, it must be respected, no matter how void or null we think it is. So until it is set aside, that becomes the order. It does appear that the person in question, the MP, will want to go the full fight it using the legal means as much as he can. So we understand a notice of appeal has been filed, a stay of execution has been filed, and they are appearing before the court on the 28th February for that stay of execution application. And if what the lawyer for the applicant told us was anything to go by, the matter is being heard every day by a warrant given by the Chief Justice to deal with such election petitions. So yes, my guest, Inus Afuseni, former MP, Tamale Central, Bobby Banson, private legal practitioner, will be soon joined by Nana Ejay Bafoiwa, MP for Menshat South, and then Franklin Kujo, who is president of Imani Africa. All right, Inusa, so we have the matters before us. Assuming, normally, if somebody comes before the court held on contempt charges, the person purges himself. Of course, we know he's fighting this, but hypothetical, assuming all the options fail, how will purging himself look like? Because his MP sworn in, how will he purge himself of that? Because the conviction is grounded on the fact that he disrespected an order of the court that prohibited him from holding himself out as MP and getting sworn in. Now all of those have been done already. How does he purge himself?
You see, there are many intervening circumstances that probably will lessen the burden on him. One, and I must thank Gary Nimako for sending me all the processes.
Okay, so Gary Nimako, was his lawyer in court. Yes, he was in court, but the court really didn't hear him because the court didn't know him.
Well on set, he sent me all the processes for so far. Now, so there are many intervening factors that can lessen the burden. One, if it's indeed true that the Gazette notification was done on the 5th and not on the 5th as alleged in court by the applicant, then that would be that could found a misleading information in court that moved the court into granting the stay, and that will lessen whatever impact that has on the stay of execution. If, like Bobby Banson has said, if they take opportunity at the earliest court hearing day to go to court to try to convince the court that processes have been filed to have the order vacated and appealing the order of the court, that itself could assuage whatever the severity of whatever sanctions the court can met on the distance. Thirdly, this is an election petition case. Now, it could be that Kumi was validly elected. It could be that, and that all this matter before court is much ado about nothing. And how will you feel punishing a rightfully elected person because processes have been brought against him? So if all these matters come before the court, I'm sure the court is going to give a reasoned judgment in the matter or look at all these circumstances and balance the requirement of fairness with the power of the court to punish. And in this matter, if listening to Bob Banson, reading what Gary Nimako has said, and reading public sentiments, even on the floor of Parliament, you could see that the majority were just saying that because of the pendency of the conviction, we won't allow him to carry himself out to make a statement and still reinforce the breach of the order. Now, but they were willing to accommodate him in Parliament if he showed processes.
File a notice of appeal and a stay.
Good. So even Parliament is willing to look at all the circumstances because of the nature of the case. It's a parliamentary election. So I do not think, initially, I thought he had just treated the court with contempt, and that would have been disastrous for him. But it appears to me that from the evidence now emerging, it appears to me that he was just, he didn't attach that much attention and seriousness to the matter in a way that is demanding of an election petition and to get himself into this mess. And probably because it's a first timer, the first time offender and a member of Parliament, probably the court will look favorably to him and might not even convict him. I set aside. The least I expect is that the court says, okay, I've vacated the order.
Because of the intervening circumstances. Yes. Notwithstanding the fact that he might have disobeyed the order of the court initially.
Yeah, but because of the intervening circumstances. Just to give him the benefit of the doubt that, look, yes, you took steps that were an affront to the integrity of the court. You took actions that challenged the authority of the court to restrain you from doing certain things. But because of the intervening facts, and especially the fact that the plaintiff's, the respondent's case is true, that the court itself was misled in court. If that is established in court, that the court was misled into granting the order, then the court will have to purge itself, not so.
I see. Bobby, do you agree? What will purging look like? Purging himself of the contempt in case all those things fail. How would that look like?
How the respondent will purge himself of the contempt.
Exactly. If all these, so we are being hypothetical now. We know he's filed a number of processes with the hope that the court will favorably look upon him, look at those processes in his favor. But it could be either way. Assuming it doesn't go in his favor, and he now has to purge himself of the contempt of court, how would that purging look like? Because does he resign as MP? What does he do?
Selorm, the sentencing, the conviction, the conviction means that I have found you guilty of disobeying my orders. The sentencing could come in different forms. The judge could say that in sentencing, I'm giving you an opportunity to purge yourself so that I do not sentence you. The sentencing could just be execute a bond that you will not repeat that again. It could be that pay a fine of 5 penalty units or 1 penalty unit, or between now, it could be a suspended sentence that between now and the determination of the matter or the repeat application. So I have not seen a repeat application anyway. I'm sure it exists because it would have been interesting if there is no repeat application. The repeat application for injunction or notice, I'm sure it exists. So the court may say that I'm suspending the sentencing until the repeat application is heard, on condition that you do not appear or carry yourself out as MP anyway. But to be frank, I align with what Senior Inisa Fuseni has said. Looking at the documents, all the legal principles that we have accepted without dissent in our jurisprudence, it will be very interesting if the judge does not either vacate the order or stay execution of the contempt, at least until the certiorari application is determined.
I see. Interesting. But so we're doing this purely as a matter of law, but we must be balancing it also against public sentiment and how the public views persons of privilege and maybe persons in the political class. There's this notion often that when it comes to so-called big men, the law is not as strict on them as the laws would have been when dealing with ordinary people. So balance all of this for me. Of course, we know what the law says and all the processes that we've seen filed and what the possibilities of all of those would be. But now you go to court, the court says, okay, because of A, B, and C reasons. Maybe there was a certiorari I didn't see before, or maybe I was misled because the gazetting was done on the 6th, not on the 5th, and all of that. So because of that, I'm vacating my order. In law, sounds solid. How do we, ensure that the public is carried along so that that perception that when it comes to big men, we are ready to bend the laws to favor them does not fester?
I think this public education we are doing through your platform is one sure way of bringing clarity to some of these issues, bringing it to the doorstep of the public so that they do not have any perception. Like it's been said, if the judge wanted to treat him as a big man, the judge wouldn't have issued a bench warrant for him in the first place. If his colleagues in parliament thought that he was such a big man and so they would disobey the court order, they wouldn't have asked him to go and take the necessary steps for them to be convinced that he is actually not merely disrespecting the court order, but actually taking steps to set it aside. So the actions, and if he thought that he was too big, a man bigger than court, he would just merely ignore it. He wouldn't have instructed his lawyers to file the processes ensuring that they are invoking the supervisory jurisdiction of the Supreme Court and also the jurisdiction of the High Court to make sure that the due process is followed for the orders that have been made by the courts to either be stayed or be set aside. So, short of all this embroidery, it is very obvious that the member of parliament involved is now, at least if he did not in the past, like Senior Fuseni has suggested, now he's taking it very serious and not merely sitting somewhere and saying, I don't care, I'm a parliamentarian, the court can do whatever they want to do, I'll still carry out my duties. He's actually taking steps. So if he is taking steps, then you as the ordinary person, you must not disrespect the law and expect that a parliamentarian will come to your aid or your political party will come to your aid, because now you see that a member of parliament can be cited for contempt and convicted for contempt, and he had to take steps through his lawyers to challenge the order. So you who voted him, you are not above the law in as much as he is also not above the law. And when I think there's an issue of Honorable Japan, at the point he was convicted for contempt, yes, and his lawyers had to go to the Supreme Court to quash the conviction. And so it will not be the first time that the courts have expressed their contempt powers against persons in society, irrespective of the level that they have reached.
I see. Honorable Minister, so I mean the same question, the public versus what happens in the court.
That perception will always be there. That look, because you are big men, the court is favorably disposed to treating you in a different way. The court will not act that way, manifestly differentiate and discriminate between classes of people in the country. In the application of law to the facts or to persons, it must suggest or appear that the court is looking on favorably towards some people, but I don't think that is so. Until I came into this studio, I just thought that the MP had acted recklessly, because, and Canada, Japan, I think in the CIF Parliament, after elections, Canada, Japan did not get sworn in for a number of weeks. He was in America, and then some people they were talking about he absenting himself from Parliament for a number of days and trying to invoke the constitutional provisions and the standing orders of Parliament against him. I remember I came on TV and said, no, you can't, because it's not been sworn in.
It's not an MP.
It's not an MP. It's not an MP. So taking a few time off to fight a case that has been brought against you does not operate to disqualify you from becoming an MP. It is not an impediment at all. Just go fight the case. And even coming to this studio and having been given some of the facts of the case, I just think that he ought to have taken the matter seriously. But the public should know, and that's what we are discussing this year. The public should know that, yes, that's a democracy. The court itself is a democratic setting. Now, and in the democracy, the majority have a right to be wrong. Okay, And so we might say that, well, we perceive it this way, but we are wrong in perceiving that way. Because when you apply the law to the facts, you come to a different conclusion. Now, the set of facts that came before the judge to come to that conclusion might be greatly different from the real facts if the matters are fought on notice by the parties. And for the general public to know that what the battle now that is raging on is on the interim application and not the
substantive matter.
It's for to maintain the status quo, okay, to ensure that nobody is unfairly treated. Before the hearing of the substantive case. Now that the matters have come to a head and the MP-elect knows that if he doesn't fight the case very well, he might be embarrassed and embattled throughout the 4-year term, I'm sure he will take seriously to it. And I've looked at the results again, and you see that there's a 2,000 or so difference between him
and the NDC guy.
So you are going to court to show that that person has not been validly elected. And you're going to prove to court that when you tabulate the results, because the results have not been challenged at the polling stations. So when you tabulate the results, you will not get what the Electoral Commission has declared. Okay, they need to show that. And so I think that, and this should be, the parties should be able to do that within 21 days or, on a day-to-day setting. Within 21 days, they should be able to finish. And I think that I'll use this opportunity again to call for a revision of our laws. And the Chief Justice has done well by saying that cases of this nature should be heard on a day-to-day basis. But the Electoral Commission must also have timelines and benchmarks for us to have these matters resolved as quickly as possible.
What should the Electoral Commission do? They will just declare they are done. What should they do? Declare early? Because they declared and they gazetted it either on the 5th or 6th, depending on where you stand. But of course, the data we are seeing is that it was on the 6th.
The Electoral Commission elects to recollect, and up now they are recollecting.
Because there are issues.
So that's what I'm saying. If we are able to reform our laws to say that election petitions must end within 14 days or 21 days, okay, consequent upon the declaration and gazetting of the results. Now, everybody, why we went to court to have matters recollated or whatnot was because we feel that if the matters go to court, they will stay in court for a very long time. Might take the whole 4 years. But if we reform our laws to say that we must conclude election petitions within a certain period of time, the appetite to drag cases will be gone. And then the Electoral Commission or people going to court with applications like coalition, recollect the results will not matter anymore. That's my view, though. That I think that because there's a legal regime that deals with how to settle election petitions or election cases, we should improve upon the regime in such a way that we disincentivize people from dragging election matters for indeterminable length of time. And in most cases for the entire duration of that parliament, so that even if they finally are declared not to have been validly elected, it will be a brutal fulfillment. It will be of no consequence. If we are able to do that, then we should be able to be fine with our elections.
Very good. So a few of some of your messages that have come through. Prince Henry in Koforidua, who says he's texting from Konongo Joasu today, says, and Kumi should carry his own cross because he was aware of the consequences before indulging in that act. It should serve us all a great lesson going forward. You say the future is pregnant. We are working the lines to speak to the lawyer for the applicant, the NDC candidate, so we get some perspective from, because a number of things have arisen in the course of the discussion. So we hear from him, for example, why they decided to go, for interim injunction when they could have served him on notice. And once you serve him on notice, it carries almost the same effect as the injunction being granted, at least until the application is heard, and all of that. All those matters. So we are working the lines to speak to him. We'll get to him.
Or whether indeed it was true that they had told the court that the election results had been gazetted on the 5th.
On the 5th, exactly.
Yes, when there's evidence
we'll put all of that to him. This one from Citizen Francis says, standing in solidarity with our MP, Ernest Kumi, we have faith in the judicial system and are confident that truth will prevail. Politicization of the judiciary is unacceptable. We urge calm and restraint, trusting that the court would uphold the will of the people. So whilst we wait to speak to him, let's do the politics of this. So what's happening in Parliament? The minority is saying that they will also retaliate because the majority found a way of adjourning the House without making the man in question read a statement, or make a statement. What do you make of the politics of the House, the numbers and everything? What can they do really?
I don't know why this particular minority, and led by Afenyu is taking this confrontational course.
Okay, so just with your thoughts there, I have Bernard Bediakon, who is a lawyer for the NDC candidate or the applicant in this matter. Counsel, good morning. Welcome to the big issue.
Good morning, and thanks for having me.
It's a pleasure to have you once again. So we're looking at the matter, and a number of issues have arisen, and we just want some clarity on this. First of all, we noticed that it was an interim injunction application you went to the court with. The court granted it for 10 days. Any reason why you decided to go with an interim injunction rather than being on notice? Of course, I know a response will be that by the time you get into serve, because you'll be evading service and all of that, things might have happened. But any particular reason why you chose to go ex-party?
Yes, so you said it rightly. We filed the petition on the 31st of December.
On the what? You filed the petition when? 31st.
2024.
Okay.
And you know the rule, what the rule says. I mean, not that 25. It talks about when you perceive that the parties involved would not be able to receive the application for whatever or for the processes that you have done. You come as party because of the urgent nature of the matter. And you would agree with me that we had sent people to the offices of the Electoral Commission for some documents, and we even sent a letter, a petition to them. They told us the offices are closed until after the activity. And so we knew that and don't forget, this matter has been reviewed to Honorable Yadobwate, that's my client, and then NSUMI. No, there are other respondents. The Clerk to Parliament is a respondent, and then the Electoral Commission is also a respondent. And you know, Council, that and so all of them are there. You cannot even have any matter heard in court. And so it's not just about NSUMI, and this was the festivities. I mean, we didn't even know the whereabouts of the NDC candidate, NSUMI. And at that point, you can't serve anybody through any lawyer because nobody has rented any appearance for anybody. These are the originating processes. So they serve on the people themselves. The PC must be served through 8 offices, which offices were closed. You can verify from them. They said they would come back as late as the 4th of April. That is what they told us. And until then, nobody can serve anything through them or on them. This is what we were told. So even before filing the petition, we knew that we won't get the Electoral Commission to serve. We won't get the Clerk to Parliament to serve because this was the defense. You see, so we knew that. It was so urgent because as part of what the release were seeking was, to restrain him from being sworn. So if you come and, if you file a petition on notice, you shoot yourself in the foot. Nobody does that. So that's why we chose that part. And it's a jail pattern. And I hear this or the alternate pattern rule. How does it apply here? The rules of court provides that you can come as party. This is not the first time. It's nothing. We do it. And it is provided for under the rules. And so I do not know why anybody would have to deal with that one.
I see. So the matters have arisen from that interim injunction order. But have you since filed a repeat application since the 10 days?
We haven't. And we see no need. The reason is very simple. We were seeking to restrain him from being sworn. He defied the orders of the court. He disobeyed it blatantly and he got sworn. So a repeat of what? He has already done what he's not supposed to do. So we don't need to repeat anything. We rather have to go into the matter and then seek remedy for his disobedience, which is the contempt action.
I see. And you said you filed the petition on the 31st of December, right?
Yes.
And when was the gazetting done? I thought the gazetting was supposed to have been done before the petition.
This matter has been asked a number of times. But you see, what I seek to do often, and our counsel, you know what we do. I don't preempt or prejudge any matter. This is a matter that is a subject of a certiorari application at the Supreme Court. It is also a subject of appeal. I mean, Gary Nimako has filed, counsel has filed processes alleging the legality or the lawfulness of the action received. And it includes the fact that he claims that the processes were premature because the gazetting was not done. We disagree completely. Let me put that on record. But you see, this is a matter that I don't want to go into. I can only talk about what has happened. But what will happen, you know, it is not the best thing to do. Because we can't litigate these matters on live radio. This is not a law court. Hopefully on Wednesday, Gary has filed a process alleging the decision of, and he's even seeking to set aside the petition and then all that. And then also there is the certiorari application that will be them. But let me just say a few things on record. Just things that have happened. But I don't want to go into this matter. I have said on record that we disagree with you on the point that there is no gazette and the fact that there is no gazette, everything was analysis. We disagree. And you will meet at the Supreme Court. And I'm sure your eyes and ears will be there. See, let me just say a few things that are happening here. Do you know? I will just ask them, put it this way, very rhetorical. Do you know that in all this, it was just 2 days ago, when was that? I think today is Saturday, on Thursday. It was just Thursday that Gary Nimako filed appearance in the matter. Do you know that? It was just Thursday that Gary Nimako filed appearance in the matter. In all this, he has been filing, he has not complied. This is somebody who is talking about procedure. They have not complied with order 9 of CI 7. Just 2 days, he just filed appearance in the matter. Now, do you also know that we had filed an amended petition because some information had come to us, and the amended petition was filed on the 12th of January. When pleadings had not closed, I think you would explain to your listeners who are not lawyers. Pleadings had not closed because Gary had not. Look, they have not even filed an appearance, they have not filed a response to their action, their origination action, which is the they have not filed any documents to counter it. And so, in our humble opinion, pleadings had not closed, and we have now filed, as far back as 12th of January, we filed an amended petition, which we filed out of right because pleadings had not closed. And they are Zulu there. So I will be shocked. If somebody at this point, you know, counsel, that once there is an amended petition, you don't refer to the old petition. It takes over completely. It takes over, and this is right. You don't need any petition to know that once there is an amended petition, you refer to the amended petition. The amended petition was filed on the 12th of January 2025. And so if today you are filing any document pursuant to the originating action, the originating action currently is the amended petition, not the original petition. Do you understand? You see, all these things are technicalities, but I expect that some people who are speaking to the market are really, or they really do understand the processes that have been found. So granted, without admitting that there was no gazette, what Gary should have done, what I, in my opinion, with due deference to him, what he should have done was to file, and there was no gazette, and he thought that it was so serious that it had an effect on it. What he should have done was to file an application to set aside the petition that was filed at the time. Rather, what he did was that he filed an application on the interim injunction. You see, the principle of you can't play something on nothing, it was circumvented because what he should have done was to file to attack the main process, which was the petition. So that when the petition is annulled, every other aspect of it is also annulled. That is not what Barry did. He rather filed an application to set aside the interim injunction, which is an offshoot of the main process. So that if, assuming it was even granted, it is the interim injunction you are questioning, not the main thing. So I argued in court that that is not what should have been done. And the court agreed with me. Do you know that? Just recently, just last week, Gary has now filed an application, just last week, an application to now set aside the petition. He has now seen the light with the greatest respect to him. He has now filed an application to set aside the petition. And it's deleted. Deleted in the sense that the application came to make an amended petition. Counsel, are you following what I'm saying?
Yes, I'm with you. I'm with you.
Yes. So it is deleted. This is pure tactics and strategy and its procedure. So the application is now deleted because the application, the old petition is not in force. The live petition now is the amended petition. So you cannot file an application on a moot application, on a moot process. The process is not live. There is an amended, and we amended it as of right. We didn't need leave of course because you have not filed anything. You have not filed anything. So you see, this whole talk, the way people are talking about, let's go to court and argue our case. So granted, and you see, the other thing is this. The application he filed, seeking to set aside the interim injunction at the time when the old petition was still live. The application sought to attack an offshoot. And the offshoot is an interim injunction which was for 10 days, which elapsed as far back as the 12th of January. As far back as after the 12th of January, there was no order against the committee because it was an interim injunction. So if you go to the Supreme Court with a certiorari or what? A moot order, the order is fine. How will I follow it? The order is fine. You see, the Supreme Court is not an academic chamber. They deal in live matters. So if the matter is moot, you don't go to the Supreme Court asking for a certiorari. But that's a different matter. We will meet them there. So granted, without admitting, and even that we disagree, and that is a serious matter that is coming up. Interestingly, all the processes were served on the Electoral Committee. The Electoral Committee has not been able to file a single document claiming that they had not gazetted the results. And last question before I leave. I didn't want to comment on this, but I'm going to see the issue of this gazette. Go and read Regulation 43 of the CI. It talks about the fact that after the Electoral Commission, the returning officers have filed their results to the Electoral Commission. The commissioners must gazette. And after the gazette, soon after, that is, these are, I don't have my, I'm driving, I don't have my list, but it talks about soon thereafter, the Electoral Commission must send or transmit the writ of elections to Parliament, to the clerk of Parliament. It tells you that there should be gazetting before the writ of election is sent to Parliament. Now the question is, the clerk to Parliament is on record to have said that he received the writ of election with regards to 274 constituencies, which included, let me put it this way, excluded only Ablik-Manoff and then Pantiapa, Ablik-Manoff and then Dobe-Kwabina. They got the Electoral Commission. Head one to order 46 of the regulation, organize the press conference or call the press conference. I'm sure you were there because you reported it. That the Electoral Commission said that they had published or they had gazetted 274 constituencies minus Ablik-Manoff and then Dobe-Kwabina. And they had remitted same to the clerk to Parliament for them to be sworn in. This was on the 24th of December. Now the clerk to Parliament on the eve of the swearing in, on the eve of 7th of January, that he received the writ of election from the Electoral Commission on the 23rd. The writ of elections on the 23rd of December. And some of note the date on the 23rd of December. That's when the Electoral Commission remitted the writ of elections to the clerk of Parliament. The question is, was it gazetted or not? Because the regulation says that it should be gazetted before remitting to the clerk to parliament. And so if it is the case, you see, there is a serious matter that is coming up. But relax. You see, if it is the case that the EC transmitted an ungazetted rate of elections to the clerk of parliament, then we all wait to see what will happen. If it is the case, because you see, you are a lawyer, you know presumption of regularity. Presumption of regularity is a simple legal phrase, which means that the act of an official, a public officer is deemed regular until proven otherwise. It's rebuttable. So you see, what happens is this. When I come under presumption of regularity, and I'm surprised they bastardize this judge, this learned judge, and who has given, I'll send a copy of the ruling to you, and on the injunctions, on the contempt, and you will see. Gary Dumaku was in court, and he actually had how erudite that ruling was. You come to court when we have come under presumption of regularity. Mind you, there is no law that says that in filing a petition you should add a hard copy of a gazette notification. There is no law. In fact, it is deemed that you know that it's been gazetted. Let's put it that way. But you don't need to add a hard copy to it to make it effective. Now we found it. Then you come and say that it wasn't regular, that it was premature because it has not been gazetted. We relied on presumption of regularity because the EC had come out on the 24th of December to say that they had gazetted it and sent same thing to the clerk of parliament. So we said that this is at the press conference of the electoral committee. We exhibited it, and I've heard them say that a judge who relies on a press conference to rule and order. Sometimes they rely on things that are less than press conferences. What then is judicial notice? Sometimes I hear lawyers, the judge could even take judicial notice of something without even looking at it.
I see.
When I hear lawyers talk, I get shocked. Because they relied on presumption of regularity. The judge told him that, do you have anything to counter the press conference as reported by almost all the media outlets? Beyond that, he also exhibited a copy of a letter or a notice from the clerk of parliament asking all the MPs to, at first one today, they receiving or he receiving the rate of elections, they should all go ahead and register. So we exhibited all these before the court, and you exhibited none beyond your saying. Let me put it that way so that non-lawyers will understand. Beyond what you said, you didn't exhibit anything, and you know the rule. You know what the court has said in the Majola case and all that. That mere saying it was not proof, and you exhibited nothing. You came to court and only said that it has not been gazetted. I exhibited at least the press conference. Copies of a report from the Ghana News Agency, even CTFM, Joy FM, who said that the EC said they had gazetted it. So presumption of regularity. The onus is now on you to counter it, to say it's a false. And you said it without producing a single document on the face of it. And remember, this is a civil matter. So on a civil matter such as this, the proof is
the standard of proof is very well.
Probability.
Very well. Great.
The proof is not beyond reasonable doubt. So as a judge, he looked at ours and he looked at yours and he said, you go with that.
Very well.
Let me say this last thing.
Okay.
It is at the Supreme Court, the processes filed at the Supreme Court, that Gary has exhibited the
Gazette.
copy of the Gazette. He didn't exhibit it at the trial court. So what do you expect the judge to do?
I see. When are you back in court?
Wednesday. They have filed a motion to stay execution, and that's another interesting one. I don't want to share my
your strategies on air. That's fine.
So on Wednesday we are meeting in.
We'll be in court on Wednesday to see what will happen.
We are also filing a response to our processes at the Supreme Court Monday morning.
Very well.
And so we will meet them there.
Very well. Great. Thanks so much, Bernard Bediako, lawyer for the NDC candidate in the Akwesea election or Akwesea constituency, Henry Boakye, Yadom Boakye. Yes, he's told us the side of the issues. Let's see if what he has said has changed anything in respect of what my guests have said. Bobby, if you are there, does this change anything? Does it change your view? Okay, so Bobby is not there. All right, so Honorable, does this change anything in your earlier submission and the processes you've read from Gary, etc.? The fact that the Gazette, I mean, there are issues with the Gazette and all of that. He is saying, I mean, he relied on the presumption of regularity and a lot of all of those. Does it change anything?
Well, and even the law, I think that he was quite solid on that. I mean, because the law actually says that, and I like his logic. I mean, the transmission of the rate of elections to Parliament cannot be done if
there's no Gazette.
If there's no Gazette. And
so that's quite interesting.
It's quite
because
interesting.
We are now seeing the Gazette to have been done on the 6th.
And this matter, actually, I looked at Gary's documents, and there's one particular document that suggests to me that there was an attempt by the embattled MP to set aside the temporary order of the court, which the court dismissed. Yes. And the court's argument simply is that, well, on the 25th, when the Electoral Commission did the press conference and said 274 constituencies have been gazetted,
that meant it included Akwetia. Because the two outstanding were just Domi Kwabenya and then Abdulkumar North.
Okay, so and that matter was published on the Ghana News Agency. So let's wait to see what will happen.
That's interesting. And he also dealt with the matter of the S party that Bobby had.
No, S party. I remember when that was a very active practice. That's what we used to do. So you file the petition and then couple the petition with an X party. You see, so when you file both, you move the X party and get the order and attach the order to the petition and serve on the. That was intended to ensure that the respondent will not take any step that would prejudice the matter.
Very well. Interesting. I wish I had Bobby's closing remarks, but he's off the line now. So this is a big issue, 97.3 City FM Channel 1 television as well. We conclude this segment of the program on this interesting note. Let me take a few of your messages, then we can move to the next subject. The Supreme Court showed a way that one could go on X party for an interim injunction. When some of us questioned the action by the Supreme Court for hearing marking on S party, we were told the court could vary its own laws. Okay, that's Dennis. This one has no name. So didn't the Supreme Court also rely on presumption of regularity when he heard the case of Afenyo on X party and said they were convinced that the speaker had been served and that the Hansard on that sitting was admissible because they saw it on TV? Well, interesting. The law is... Anyway. All right, so we take a short break. When we come back, we'll look at the discussion on the public sector salaries or wages increase and how government is honoring the DDEP payments. 97.3 City FM, Channel 1 Television. My name is Selorm Adonoo. The program is A Big Issue. We'll be right back.
In the celebration of indigenous authenticity in our Heritage Month. Join us for the Heritage Month launch on Friday, February 28th as we kick off a month of unforgettable experiences. Pack your bags for the Heritage Caravan, a week-long adventure across Ghana from March the 2nd to the 9th. Discover the beauty and history of our land. Savor the flavors at the Back to Your Village Food Festival, a culinary extravaganza on March 29th and 30th. Taste the essence of Ghana. Tune in to the Heritage On Air series on 97.3 City FM and Channel 1 TV. Feel the rhythm of our music, journey through our religious history, and indulge in indigenous Ghanaian food. Join us to celebrate our heritage this Heritage Month, where every moment is a story. Only on Channel 1 TV and 97.3 City FM.
Of their neighbors, toils of the brave, which have brought reform.
You're welcome back. This is a big issue. Just gone by as a discussion on a lot of legalities. So now we're dealing with money. So, I mean, Akwetia and contempt and all of that. And now we move to the next segment of the program where we look at what government has been doing on the economic front, raising public sector wages by 10%. Many have said it's been woefully inadequate, but President, who unexpectedly was in the meeting, justified that by saying that the economy was, what he saw was a criminal handling of the economy. Quite some strong words there. He also said that the country, Ghana, was a crime scene. That's strong words. And that the situation was so bad that they could only afford 10% increase. And he promised that should things improve next year, we'll see better. Of course, this was coming at the back of a 25% or so increment the year before. And people were expecting to see a similar quantum, but this time around just 10%. So that's what we have. 23% the year before and then 10% now. Now, let me just provide you some updates. So government has approved a 10% wage hike for public sector workers following successful negotiations with labor unions and the president or the team government. The latest pay rise shows or follows a significant 23% salary adjustment in 2024. The following report has more.
The 10% wage hike marks the second wage adjustment in less than a year. President Mahama personally engaged with union representatives to secure their support for the increase, underscoring the government's commitment to easing financial burdens amid economic challenges. Organized labor had previously called for an increase in the base pay, and according to the Labour Minister, Dr. Rashid Pelpo, the daily minimum wage has now risen to 19 cedis 97 pesos.
An increase in the national daily minimum wage by 10% over the 2024 national daily minimum wage, which translates into a new national daily minimum wage of 19.97 Ghana cedis. The effective date for the implementation of the 2025 minimum wage shall be 1st of March 2025. All establishments, institutions, or organizations whose daily minimum wages are below the new rate should adjust accordingly.
The president assured the public sector workers that they'll receive higher remuneration if the economy recovers next year.
It is said that we create and share. And so let's start cooking the meal now so that we can share when we have created. But right now, the meal is not only insufficient, the cooking pot is even leaking. And so I'll just appeal to you that let's temper our demands for this year. And once we get out of the woods, we've set good targets to bring inflation down so that the cost of everything will come down. We've set targets to grow the economy, to make things better. And when the cake is big, then it's bigger. We'll share bigger. We are proposing an independent emoluments committee that would set the incomes for everybody from the president right down to the ordinary laborer.
President John Mahama, while speaking on the economy, says he has discovered that the economy was criminally handled by the previous NPP administration.
We all knew the economy was in crisis, but some of the things I'm discovering myself, I mean, it's been a criminal handling of our economy. And Ghana is a crime scene, actually. Because how a government can have been so reckless, I cannot understand. But we're faced with a reality, and our options are very few. We can behave like the ostrich and hide our heads in the sand and let the economy crash. But then what effect would it have on Ghanaian households and everybody?
All right, welcome back. This is the big issue. My guest on this segment, Honorable Inusa Fuseni, former MP Tamale Central and Minister for Main Portfolios. The Honorable Chunibwa Foko, MP Manso Kwanta, former MD, the NIB Professor Godfred Bopping, is an economist, University of Ghana, and we may have Thomas Musa as well, General Secretary of NAT, joining us. We'll look at the public sector wages first. Before, like we heard in our report, it was 23%. I mean, sometime last year.
25 effective. 23 January to June. Then 2% July to December.
Okay, so cumulatively, that was 25%. Yeah. Good. But this year, we are just seeing 10%. We don't know what will happen later in the year, but at least for now, we have 10%. Labour initially wanted something in the region of the 20s. I think the government has started with 3 or 5%, and eventually they climbed up to 10%. The president unexpectedly was in that meeting, and many have said that his intervention was key to get Labour to cooperate with the government and all of that. Let me start off with Minister Fuseni. Government is taking power. We were expecting good things, resetting, etc., etc. Inflation is still in the north of 20%, and I mean, we're waiting for the wage announcement. It is just 10%. That is woefully inadequate. When you look at it, that brings it to some 598 Ghana cedis for the month. That obviously cannot do much for people in the lower tier of the economic ladder. Why couldn't we have done better with the hike? 10%, so small. Many have said.
Because there's nothing in the pot. We have a leaking pot, not so. So you can only give what you have. But let me backtrack to say that I have followed Labour for quite some time, and I'm happy that Professor Bob Kane is here and Boachi Adom Junibua is here. Junibua Foucault. You know, in 2008, when President Kufuor was leaving office, he left the implementation of the single spine to the incoming government. And it was going to be a big chunk of money drawn from the public purse to satisfy and implement the single spine salary structure. Labour was very understanding. Labour advised Professor Mills that if it was going to be difficult to implement the single spine salary immediately upon assuming office, he could defer that. After all, that was not his act. Labour did that. So, what Labour has done is not new. They have been
consistent.
They have been consistent. They are reasonable people. They understand the situation of the country, and so they are prepared. And like the one American president said, they are prepared to give back to the country and not ask what the country can do for them. So I commend them highly for what they have done. The truth of the matter is that, and again, Prof is here. I mean, economists will say that if you want to keep the purchasing price parity, you want to keep the equilibrium of the PPP, purchase price parity, you have to match salary increases with the rate of inflation. But that has got also an adverse effect. Immediately you match it, you drive inflationary trends again. Because when you drive it and it's equal to production, probably you are able to save the country or the workers from the inflationary trends that an increase in salary will bring. But you're talking about the public sector. The economists have been at pains to try to quantify what productivity means in the public sector. So you're going to face inflationary trends, whatever, even if it were 3%, you're going to face inflationary trends. But suffice it to say that since we have not been able to match the salary increase with the level of inflation, they are going to be worse off, a little worse off, because their purchase price parity will definitely reduce. But that is the sacrifice. That's the sacrifice they have been able to give. Now, why have they been able to do that? One, goodwill. Goodwill to the president. You see, they are Ghanaians, we're all Ghanaians. And so, if the country is prosperous, if we're able to meet the promise given to the people of this country by the Constitution, creating equality of opportunities and prosperity, we, the people of Ghana, become the beneficiaries. And so, if there's a new government, you want to give the new government the benefit of the doubt, to see whether the new government can engineer policies that could bring about the equality of opportunity and prosperity promised by the Constitution. So you look at it on the goodwill basis, they've done exceedingly well. When we were campaigning, we said we wanted a president we could trust. We wanted honesty. We wanted leadership. And so when John Dramani Mahama, the president of the Republic of Ghana, sat in the meeting, he connected with them emotionally. And then spoke to them in ways that they were prepared to give him the benefit of the doubt. And in Legon, the Legon Hall motto is that to whom much is given, much is expected. Now Labour has given the government the benefit of the doubt.
So government must not deliver.
Government must now deliver.
Labour will not take excuses the next time.
Government must deliver. Government must deliver because they've given us the benefit of the doubt. They said, look, we know that inflation is eating away our monies. We know that we can't make ends meet. But we are quite understanding of the situation in which the country is. That we are also citizens of this country. That you have come with policies. We want to give you the benefit of the doubt to implement those policies and see that how that policies or those policies can translate into prosperity for the country Ghana. Because if we are prosperous, we all benefit.
How crucial was the president's personal attendance?
That shows leadership. That shows concern.
But that also shows that I have people to do the job, but I didn't think they could do it, so I have to be there myself.
That shows that he's added them with his people. Because if you read Article 58, you will be left in no doubt that the executive power, the power to increase the wages
resides in him.
It resides in him. You see, he only delegates those powers to his Minister of Labour, his Minister of Finance and whatnot. But he is the power.
So how consistent is he going to be with that? Is it a case anytime there's difficulty in arriving at a consensus, then he has to make an appearance?
But that's not the first time he's
made an appearance. I hear it happened in 2013.
In who?
Yes. But now it's the same person again.
Yes.
2013 and 2025, we've seen him again.
Yes.
So tomorrow, if there is a difficulty, there's a deadlock, Labour, instead of listening to the minister, will want to see the president himself. Doesn't that reduce his weight or power?
You know what?
In the eyes of the people, they want to see him.
I know, and I've been shown documents. I've been shown things that clearly, probably, the leadership of Labour were probably shown those things, and that pushed them to understand the precarious situation in which the country is. And you simply cannot give what you don't have. And so, having said that, I just pray to God that our appointees at all levels of the system understand the situation in which we are and work their backs to reset this country. Because if Labour sees any sign of recklessness on the part of this government, or of wastefulness on the part of this government, of corruption on the part of this government, they might not be willing to give us another chance, and they will take their pound of flesh.
I see.
So I just hope that we will reset, we will put things in order in such a way that we can continue to inspire that level of confidence that many more, apart from organized labor, many more Ghanaians in all fields of life will make that sacrifice. That sacrifice that Finland made after their war with Russia to rebuild their country, where women had to bring out their gold trunklets and gold chains to sell, to give to the country, to rebuild that country. That when we have genuine leadership, a leadership that cares for the people, we will get there.
I see. Prof, 10% in the face of rising, with inflation is not particularly towards a certain trajectory. It's been undulating back and forth, but it's still above 20%. Just 10% is insignificant, really, because inflation will eat out a chunk of that, or will eat that out completely. Is the Ghanaian worker not left more impoverished, even in the face of this hike in was it a minimum wage?
Well, certainly, yeah, that is where we are. I'm not too sure. Labour went into this negotiation with the aim of breaking even. I'm not too sure that was the goal. And I want to believe that in this particular instance, government had a stronger bargaining power because government had preempted, some way, somehow, was at the head of the curve in terms of showing leadership. And if you look at the communication of the president and government, cost-cutting measures, lean government, they've reduced the number of ministers to 60.
Currently we are 42.
Yeah, but we are planning with 60 because he had indicated that we have 4 more deputies that will come. So that is how we are looking at it. Beyond that, there have been other cost rationalization measures. And every statement of the president reinforces that kind of efficiency, lean government, modesty, and all of that. Now, if you back this up with a goodwill, I will call that one the honeymoon effect of a change in government and all of that, then you realize that at the negotiation table, it's going to be difficult for organized labor to hold out for more and all of that. And I want to believe that it was clear to all parties that this year is more or less like, this is our honeymoon presentation to you, and we are going to monitor development. And the president himself indicated that in good times, we'll remember you, and all of that. So looking at it, of course, if you look at it over a period of time, real wage typically has been negative, right? We haven't had a time where we see that consistently real wage, nominal wage can go up, but if you look at rise in prices and all of that, really, real wage has been negative. And that is why, particularly the crisis we saw towards from the third quarter of 2021, it was actually a crisis of the middle class, right? And it was a leveling up crisis. So if you look at the data, you see lower middle income poverty rising sharply, upper middle income poverty rising sharply, because you see that inflation jumped and wage couldn't match up with that. And when you see the gap, I mean, 2021, 2022, and the rest of, particularly food inflation, that takes almost between 42 and 44% of our disposable income, then you realize that really organized or labor, the worker really has suffered enough. I hope that with this new regime, there will be consistency. We've seen that before. Anytime there's a regime change, you see that on the back of that goodwill, we tend to be more transparent in terms of whatever that has happened and try to let the people know what the real situation is. Sometimes the goal is not because we as leadership want to learn from this, that we will not repeat this. The goal is more either to make the other party look so bad as they exit, and to also create room for us to be able to moderate things. That's what we've done to ourselves. You can see that in 2001, when there was a change in government. On the back of that goodwill, in fact, utility prices went up by more than 60%. I mean, things were so drastic. Not like, everything was like, look, if you don't act, Ghana won't be there the following week. Fast forward, 2028, 2029 with the change.
2008, 2009.
Yeah, 2009. Fast forward, after a regime change, we saw that. On the back of that, quickly we went to IMF in July 2009. So between July 2009, July 2012, we were under the IMF. Then fast forward, 2017, there was a regime change. Look, you go and look at the 2017 budget and the State of the Nation address, the first one the president gave, the kind of country that was painted to us, of course, ostensibly to make the previous government look some way, right? And then also interestingly, if you look at the manifestos of the two main parties, the 2024 manifesto, the preamble, how the NDC described the economy, the state of the economy, in the run-up to the my big bosses.
Yeah, you need to read that part.
Yeah, you need to, and then so that you understand that all of this, there's also a game, right? And all of this will play out in the negotiation. So if you look at the state of the economy the NDC described, it looks as though we had not even left Egypt, let alone to get closer to the promised land. Then, just a couple of flips. Look at the NPP's manifesto 2024 and look at the state of the economy they describe. It looks as though we're just about entering the promised land. Okay, so all this, of course.
But shouldn't we, so what's the reality? The reality should be somewhere in the middle.
Yeah, yes.
And who tells us the reality?
Of course, we have independent data. We are also monitoring and all of that. I think if you look at where we are, we can say that, of course, if we use 2022 as a benchmark, that was a worst case scenario for us. Inflation 54.1% and all. We can say that we've gone past that worst case scenario. But again, it doesn't look like we are out of the woods. We still have a lot that we have to do. If you look at the IMF report, December 2024, the situation is still is quite fragile. And here, let's just look at things. Look, 2022, we're comparing Ghana to Sri Lanka.
Yeah.
Ghana to Zambia. These were our friends at the time. But if you look at inflation in Zambia today, inflation in Zambia a year ago, and you see the progress they've made. Wow. Inflation in Sri Lanka, I think in 2022 was more than 57%. Inflation in Sri Lanka today is less than 3%. In fact, food inflation is less than 3%. So these countries had similar crises. But if you look at the progress that they've made, particularly in bringing down food inflation, because the reality is that once you see spike in your food inflation, it affects. There are so many things you can plan around, right? I mean, you can disengage after engagement. You can postpone childbirth through family planning and all of that, but you can't postpone hunger. So every country takes certain things very seriously. Okay, and that is why advanced countries, they will not talk about food security. They will be more particular about food sovereignty. We should have total control as to what our people will eat, that it should be available. And look, December 2024, Ghana ended up with food inflation of 27.8%. So come to think about it, that over a 12-month period, right, food inflation on the average have gone up by 27.8%. Okay, when we are saying that effectively wage increment was, let's say, 25%, that doesn't leave the worker in any better situation. But of course, again, also, if you are looking at it futuristically, if everything should go according to plan, then we are saying that probably we should be returning to single-digit inflation in 2025. Okay.
2025.
Yeah. Per the IMF-supported program, by the end of 2025, inflation should decelerate to 8% with a symmetrical rate of 2%. In other words, 8% plus or minus 2, meaning that we are looking at inflation band of 6 to 10%. Right. So if we are able to achieve that, then probably on the back of that next year, we'll begin to also look at things progressively. But let me say this. Government may have gotten away with this increment, but I think people are watching. As you rightly said, and it's not just the president alone, across the entire government machinery, right? So we should take Ghanaians seriously. Government should take Ghanaians seriously. If you look at it, right, in the last couple of years, some of the things that find their way into the wage negotiation, they are not really technical considerations. Some of them have to be just the lifestyle of government. People are watching. Okay, so, and the public sentiment, all of that feed into the wage demands, for which reason organized labor will hold out for more. Because you can't tell us that we should fasten our belt when you didn't even have a belt on in the first place. Okay, and all of that. So I want to believe that it's small, 10% is very small, but I think we have accepted that. Let's go back to work. There's a part that we also have to do in increasing productivity. There's a part that we also have to do in terms of holding government accountable. There's a part that government also has to do in all of that. But I want to believe that, of course, as the data, the more you have access to the data, the more you see that things are not that good. There's a lot of work that we have to do going forward.
I'm interested in what accounted for the progress in the Sri Lanka situation and the Zambia situation and what has been derailing ours, but I'll come to you later on that. Honorable Foucault, so your side has said that you left, like you just said, 25% increment the previous year. This is 10%. This is less than half of what you did the previous time, and you were expecting that things would be better. But the president has laid the blame squarely at your door that the economy was not handled properly. Even he called it a criminal mishandling of the economy and declared Ghana as a criminal or a crime scene. These are strong words coming from the president. I mean, he said they anticipated that things were bad, but the discoveries they are making, make him feel like Ghana is a crime scene. These are damning. This is a damning verdict on your record as a government.
Yeah. Thank you, Selorm. Thank you very much for having me. So firstly, on the 10% that has been agreed, I mean, I take it that yes, leaders of the various organized groups, they've gone through negotiations and they've signed to this 10%. So that one is signed to already. But firstly, I'll take this opportunity to commend the ex-president, Nana Addo Akufo-Addo, for showing love to the public workers of Ghana, giving them 30% increase in 2023, giving them effective 25% in 2024, based on the strong economy that was eventually handed over. And I believe the people of Ghana, the public sector workers really appreciate the love that the ex-president showed them. On the issue of, the economy having been mismanaged and all the words that are being used to describe it, I mean, I get really surprised. Because the figures are there. These are not things that you can hide. The figures are there. The economy that was handed over to the current government. I mean, you have an economy that suffered significantly during the COVID, rebounded, and still managed to hand over real GDP growth of some 4%, which is really decent for handing over real GDP growth of 4%, handing over balance of payment, very strong balance of payment of $3.1 billion US, very strong end of the year. An economy, if you want to test it again, one of the litmus tests to show whether an economy is strong is stock exchange, because companies are listed there. Strong companies are listed there. The composite index there, year on year, grew by 56.2%. This is a fact. The market capitalization significantly improved. Okay, so with all these, would you describe this economy that has been able to increase public sector wages by 30% 2023, 25% 2024, stock exchange composite index increasing year on year by 56.2%, with balance of payment positive, that is surplus of $3.1 billion. All these, you call this economy as having been mismanaged, then, I mean, what figures are we working on? Real GDP growth under these circumstances, 4%. What figures are we working on? So I will commend once again the ex-president for showing the love and demonstrating it through the payments that he made to the public sector workers, 30%, 25%, showing the love, and the fact that he handed over an economy that was really strong, an economy that had rebounded from the COVID era all this way to the figures that are demonstrated. So for me, I'm just landing. Okay. For me, the 10% should not be linked to the fact that an economy was mismanaged and whatever and was handed over in tatters or whatever, I've given the figures, and the figures are there for everyone to check. The economy that was handed over. So if, I mean, the 10% was agreed through negotiations with the leaders and all that, whatever, that is fine. That was their agreement. It's their prerogative. This is fine. But the economy that was handed over was not in tatters, and the figures are there.
So you mentioned some indicators as well. So inflation is a major one. We say inflation is a tax on the poor. Major one. I mean, that has not been accounted for really. We have rate of borrowing, interest rate, very, very high. I mean, one of the highest we've had over the period currently. So we have other factors that affect the ordinary person. You know, fuel prices, I mean, exchange rate, all of that. Those things affect the ordinary person more than maybe the rate of growth. Those things are important. But in translating to the ordinary man, inflation, exchange rate, and all of that affect the people more. But those ones have not done well. So if the conversation is that you left the economy in tatters, that could be referenced to these indicators I've mentioned: inflation, exchange rate, interest rate. What do you say?
Yeah, thank you. So, I mean, the figures I gave out are strong indicators that also show itself in the areas of inflation, in the areas of exchange rate, and all that.
Like stock exchange. I mean, very high level will play.
They work in tandem. Okay, so I mean, inflation, yes, but we've seen inflation go down. There's been a bit of an uptick, but always it is good to go down to understand why inflation at a point in time is up or down. Inflation now have seen a bit of an uptick because of the food basket. And the food basket, you ask yourself, what has caused that? And if you go down, you understand it's more of the weather, the delay in the rains, and all that. It is not because our farmers are not doing what they have been doing. It's not because the government support through the brilliant program of
Planting for Food and Jobs.
Planting for Food and Jobs has been, was not managed well. We know the support that has been given to farmers and the country as a whole through the second phase of the program and all that. So all those have worked, but we've had poor weather, we've had delays in the rains and all that. If you read the Statistical Service report, you understand the basis for the inflation that has had an uptick. The exchange rate, I did mention the balance of payment figure that we left end of the year, $3.2 billion in surplus. And if you're talking about exchange rate, the key indicator or the key determinant of the exchange rate is balance of payment. And that is how come around, the first 3 quarters of last year were not all that good. But as you got to the fourth quarter, you saw the improvement. And we left a balance of payment surplus of $3.1 billion. So you saw the improvement. So all these indicators, if you take them one after the other, you will see the work that the NPP government did to make them better. So inflation, I've given you the indications that if you go deeper into it, you understand it better. The exchange rate, where it started from, and the improvements as we got to the last quarter, and if you see a balance of payment of $3.1 billion, it should be something that we should all pat ourselves, in the back.
I don't know what your reference point is, but the Mahama people or the government side, their reference point sometimes is in 2016. So when you talk about exchange rate, it went up, it's come down, and all of that. What's the reference point? In the middle of your own administration, when you had total control, when you talk about inflation, they left around 15 or 16, 15.4. You took it to 54.1, and we are now around 23. So what's the reference point? Is the reference point when it was highest under your watch, or when you took it at the lowest, when at a relatively lower point when you took it over from them? So what was the reference? So when they are comparing, they will not compare your regime to your own regime. They will compare your regime to their regime, what they left behind. Interest rate was lower, exchange rate 4% or I mean, 4 cedis or 5 cedis to $1, you know, and all of that. So, so when they put all of that, like unemployment now about 14% before you left. When you put all of that together, and they say the economy is in tatters, these are the references I think they are making, and not using when things were very bad in the middle of your tenure, the 54.1% and all of that, the height of COVID. That's not what they are looking at. They're looking at what they left behind.
Let me add to what you have said, that Ghana does not exist in isolation. So if you look at Ghana relative to other countries, even our regional peers that were equally impacted by this crisis, you see the rate of recovery. If you look at Cote d'Ivoire, look at Rwanda, Kenya, okay, their economic progress after COVID.
They have recovered better.
Much better.
So hang on, I'll ask you to deal with that, together with Sri Lanka. Why have they recovered better and why are we not doing good? So will you want to address that?
So all that I was trying to address is the issue of complaints about what was handed over to them. And I was giving a reference as to at the time that we handed this economy to them, where we were. And it wasn't as bad as being painted. If you've gone into negotiation and handed over 10%, just few months after your previous, the previous government was able to do 25%, and if you have gone in and given 10%, then you are comparing the two. What really changed? And they are saying we handed over an economy that was so bad. And that is why I'm giving the indicators as of the time that we were
the economy was
office.
so bad, you couldn't have given 25%.
We couldn't have given 25%. So that quick, I'm coming. That quick change, really what has happened? They claiming they've seen something that is so bad, which we don't know yet. What is it? But I'm telling you, at the time that we were handing over, these were the indicators, and we were able to do 25%. For 2024, 25%. The prior year to 2024, we did 30% with the same economy, and payments were made. And I've given the GDP real growth rate that we also handed over end of the year. I've given the balance of payment that we handed over at the time that the change was made. So I understand the fact that we can compare years back but sometimes when you do those comparisons, they don't align well. And I believe we know. If I pick prior to 2020, I pick 2012, and I say 2012 exchange rate was X amount, and 2024 it is this. There are a lot of changes that would have happened in the economy.
But you politicians have made us do that.
No, I understand.
Because it favors you at some point.
I understand. But at this point in time, what the other side is saying is what was handed over. And I want to disprove that. That
if it was as bad as they claim, it wouldn't have been 25 before and now it's 10. So what has changed in between?
And 30, the 2 years before. And the other parameters that I've given, that if you want to really do a litmus test, look at the stock exchange. It's independent. Different companies, irrespective of whatever, they have no political coloration or whatever. Different entities put in a basket. What is the performance? We have seen the composite index, and I indicated, grown by 56.2% year on year. Do you need anything else to convince yourself that the economy had rebounded and was doing well before it was handed over? So what was handed over, to me, if you look at these indicators, was not as bad as being painted. But if you have decided to give the public, sector workers 10%, and the union leaders have accepted this, like I said, that is their prerogative. We know where inflation is currently. So if you look at, in reality, in real terms, if you net off inflation of the 10%, in real terms, they are in the negatives. But I'm not going to say it's A or B or it's blue or whatever. I say they went into negotiations. They've been able to come out with 10%, but I commended Nana Akufo-Addo for doing 25% and 30%, and handing over an economy that was strong. And I've given the indicators at the time when it was handed over.
Very well. So a very bad economy, you want us to believe, was able to manage 25%. And a few months down the line, don't know what has drastically gone bad. We're just giving 10% with the excuse that the economy was mishandled in a criminal fashion. You know, what has changed?
So first of all, you need to understand, and we are happy that I'm not an economist, I'm a lawyer. And I'm happy that Professor is here. I don't know why you are celebrating 30%. I don't simply understand why you are celebrating 30%. When you increase the salary of somebody by 30%, you are compensating for a loss. A loss in real income. So when, probably you worked in Europe, have you seen any European country increase salaries by 30%?
I'm not
no, please. You can note it down. You are compensating for a loss. It means that the institution is so bad that to compensate for the loss, you have to raise the salary. And it's a spiral effect. That when you raise that salary that high, you compound the problem. And you cannot see, we can all see why it happened. What do you think they got the 30% to increase salaries by? Printing of monies from the Bank of Ghana. Printing of monies. Not that they worked for it. When they printed the monies and gave to government to increase salaries by 30%, we threw more than 1 million people into poverty. You don't see the nexus, you don't see the connection. You don't see it. The 1 million people had to struggle to come out again. When you say foreign reserve, within the period that you declare DDEP, what foreign loans were you servicing? What foreign loans were you servicing? So you think that if you were servicing those loans, you leave a reserve of 3.1 billion? You think that you leave it? No, you see, this is the impunity that made the people of Ghana vote so massively against the MPP. Because they think they were fools. My brother, in 2016, if you had 4,000 Ghana cedis or 4,200 Ghana cedis, you were holding $1,000. You were holding $1,000. In 2024, you were holding 4.2 million Ghana cedis. How much were you holding? How much were you holding? Less than $500 dollars. Less than even $200. And the economy had improved. This is why Prof is telling you that the middle income people and salary workers were those who suffered the most because their salaries were stagnant. They were benchmarked to the what? To the city. And the city was falling like dry leaves in the Hamilton. That is the problem. So I'm not saying that 10% more than compensates for the loss that labor is. I've not said that. We're not even going anywhere yet. Look, the TDF. People who save their entire lives, DDEP, their entire lives, with the hope that when they go on retirement, that money will carry them until their death and leave what they can leave for their surviving children. Had to lose. Do you know what that did to Ghana? And the economy was strong then? Now, if the economy was strong, we won't go to IMF and say that, well, probably give us 3 billion support. Give us 3 billion support. If the economy were that strong. So no, I'm talking about salary. Why Labour has done what they have done. They have been very magnanimous. I know. I'm a farmer. In 2017, I knew how much I bought 1 liter of diesel for. I was already into the farming business. And I knew by 2024 how much I bought a liter of diesel. So it was not about rains. I knew how much I bought a 50 kilo of fertilizer, MPK4, in 2016, 2017. and I know how much I bought it in 2024. It's not rains. The chemicals that I use on the farm, it's not rains. It's because life became very, very difficult. Do you know the number of businesses that folded up in this country between that period and the reference? So yes, we are saying that it's difficult. Has been a difficult situation. We need to rebuild this country. And we're not going to rebuild this country by praising people who have led us to where we are today. Anytime I hear comparisons we have done well, I say, what is the basis? What is the litmus test? I mean, repeating mistakes has never been considered as experience, has it? So in 2016, MPP said NDC had committed errors, gigantic errors. And if we wanted to know how not to manage a country, it was to look at the performance of the NDC. Then the debate was the statistics, the stats. Then the Ghanaians were convinced. I mean, were even convinced to the point that they had told us that they were going to move the country from taxation to production. And I agree with them, because taxing makes people poorer. I said, oh, if you are going to do that, then many people agreed. I didn't vote for them, though. But many people believed that they were going to do a wonderful thing, because productivity is our problem. So if you are not going to be taxing the people, even taxing the poor,
if you are going to
produce,
then that's a good one.
So you are going to make room. We are going to make for the shortfall in deficit by production and not by taxation. Wonderful. Then they gave them the power.
But they did.
They didn't improve. Let me conclude. They didn't. For the 8 years MPP stayed in power, they didn't improve one single stat that NDC left in 2016. Tell me which one they improved. Not one.
No, the growth rate.
What growth rate?
NDC left 3.6, but in fact, we're just hearing, or we know that they left almost 4.0.
You know the conditions that left.
And then even before
the conditions
that came, we're top of 6.
You know the conditions that
averagely 6.9.
The average is 6.9.
Yes. So that was an improvement.
At the exit point. NDC, when they were in power, we
no, but at the exit
11%.
No, that was oil.
Please.
That was oil.
The same oil played a role in 2017 and 20.
I see. There were 2 more wells. There were 2 more wells in 2017.
Yes.
Okay.
But 2015, we can trace it to 2015, 2016 interventions in the oil that gave birth.
There was a sacrifice that was attended.
Professor, this we have gone through. We have gone through all these debates, and we can debate it. If we take oil out of the growth that they are now talking about, you get nothing. So we know what we're talking about. We're saying that let's put the past behind us and work together to rebuild this country.
Now, putting the past behind us also means that not referencing at every least opportunity.
Referencing the past becomes a guide. I'm talking about wastage. We all saw it. And Prof has told us that one thing that the Labour will be looking out for is to see whether we will repeat the mistakes of the past. So Labour has what it considers as mistakes of the past. So that past, when we refer to it, we are referring to it as a guide. We must not, you see, I've said it somewhere, and I'll say it on this platform. NDC as a government cannot afford to fall up to the level that MPP fell, or even lower. Lower is an annihilation.
Lower will not be good for the country.
It will not be good for the country.
It will not be good for our democracy.
It will not be good for our democracy. So we are acutely aware that there is a heavier responsibility. Look, have you looked at the democracy index? People are losing
faith or confidence
in democracy.
From CDDR full barometer.
The barometer report. It should be because why are they losing if we are doing so well? Because if we are doing so well, then we are saying that the dividends of democracy are good. So please, once again, I'm standing here on behalf of the NDC to salute Labour. I know we could have done more, but Labour also understands. I think 2 years ago I was reading UK, where Labour was asking for an improvement, an increase in salary, during the COVID. And the argument was how that will drive inflation.
Because the pass-through is very strong.
Strong.
U.S. advanced countries
Yes.
are very mindful of wage-led inflation.
And all how that will drive inflation. So to say that you increase wage by 30%, and what was the real increase? What's the real increase?
So that's a question.
Yes.
Yeah. So talk to us about how other countries were able to improve quite drastically.
Before you look at Sri Lanka.
Yes. Sri Lanka was
you know,
bad.
It
and
was
even
so bad
in
that
2022, we were all scared of getting to the Sri Lanka level.
Yes, it was bad that the government collapsed.
Yes, the top. I don't know why they went to the government house. People were swimming in the president's pool and all of that. Those were interesting times.
Ghana was
what should we do? What did they do to recover so quickly, and why are we not recovering?
Of course,
as fast?
They also went to IMF and all of that, got that support, monetary tightening, but also more importantly, the fiscal side, fiscal probity is very important. Okay, you see, the point is that look, and if you look at Ghana, if you look at the injection of excess liquidity into the economy, the money printing. At some point, the central bank even denied it. But in 2022, if you look at the domestic debt exchange, we were talking about 77.6 billion cedis by way of overdraft lending to Ghana government. 77.6 billion cedis injected into the economy. What do you expect? We say inflation. How does it come about? When aggregate demand exceeds aggregate supply. And what is the source of that excess aggregate demand? It's coming from the excess printing and injection to the extent that they didn't go to the productive sectors of the economy. It is not unexpected to see inflation go up the way it is. And then since then, all that we have been doing through monetary tightening, tiered reserve requirement and all of that is just to mop up excess liquidity. And the more you are mopping up excess liquidity, remember, it's going to have implication in terms of access to credit by the private sector. So the economy's productive capacity has not been enhanced in the last couple of years. And once it happens that way, you're going to struggle. Even if you talk about the food inflation, as you mentioned about, you look at post-harvest losses. Our farmers have been very hardworking.
There was an intervention by Dr. Koto, the former Greek minister, of bringing in the food from the hinterlands and all of that.
We should go to the ministry and go and buy plantain.
That
was really helpful.
That was just one.
We could have expanded that.
No, but he didn't expand it.
Cities.
Yes.
No, it takes time to do that.
No, but he abandoned it. It didn't happen. He didn't continue.
He didn't abandon it.
If you go and carry plantain and then bring it to the ministry to sell,
no,
we are.
That was just the start.
That was a manifestation of a failure.
That was just the start.
The failure. That was
But why didn't it happen?
For food and job.
Sorry?
Why didn't it happen?
No, it was a process.
But he started it. He was the one, championing it.
He's been there for a very long time.
It didn't go anywhere.
You don't start these things and go boom. You start a pilot. Sometimes you pull back to look at how it went, whether, you had to pull this here and there to perfect it, and so on and so forth. So it was started. It was a piloting. And I believe there was a bigger...
A lot of people think the program was not popular. So if you are defending it, then it was not popular to a lot of people.
I think you need a lot of time to defend
it. A lot of people actually disparaged it. A lot of people actually disparaged it and called it all sorts of names. But let him land substantively so that I can come back to it.
So there are structural issues that we have to face here. Even if you look at the food price build-up, transportation costs, we've been talking about constructing roads, rural access and all of that. Where are those roads? So, and linking farmland to market centers and all of that, very weak. Look, sometimes, of course, I came from a typical village. If you look at what our farmers go through during harvest season, sometimes when it coincides with the rainy season, post-harvest losses. Come on, this is a country that has abandoned farmers. There's no linkages and all of that. Farm input doesn't get to the farmers on time. The diversion and all of that. Look, We say some of these things in private, like Ghana is a crime scene and all of that. If you look at some of the things that we do to ourselves, we will be unique to expect a different outcome. If you look at Sri Lanka, the fiscal discipline, the people were so angry that those who took over, they were scared to even abuse the dollar. But we've gone through this worst crisis, but leadership didn't show in Ghana that there was really anything happening. Look, we are talking about food inflation. Look at what illegal mining, irresponsible mining has done to our farmlands. We are talking about cocoa. Ghana is not known for cocoa. What have we done with the cocoa sector? Look at
Ghana is known for cocoa.
Where is the cocoa today?
Ghana is not known for cocoa today. But we are the number two. We are number 2 in the world.
Yeah, you are number 1.
Yeah.
You are not celebrated number 2.
But many years ago.
But you are not celebrated.
So it's just because so many countries are not in today. But look at what is happening in South America, okay, and the other places. But look at your cocoa outputs. And when I say we should not be known for cocoa now, other critical aspects of the economy are actually bringing much more effects
than the cocoa.
Than cocoa. Even apparel. The apparel is bringing more than cocoa is bringing now. What is it? Since cocoa, we have not been able to sustain it.
I think we will do less than 500.
Yes, we have not been able to sustain it. Our farmers are trading off their cocoa farmland for illegal mining, for other cash crops and all of that. Look, we don't have a clear national policy to preserve farmlands in Ghana here. Look, in the 70s, we had Operation Feed Yourself and Operation Feed Industries. That policy probably worked in the short term. But today, that policy won't work. Do you have a backyard? The threat of urbanization, real estate, and all of that is pushing farmlands further away. With bad road network, even if you wanted to do farming, it's quite going to be very difficult in the urban areas. But when you go to London and the rest of that, you see farmlands in the heart of the city. You see it. We have destroyed all of that through real estate, urbanization, and all of that. We are not preserving farmlands. We are not linking the farmlands to market centers and all of that. Then suddenly you expect that the numbers will show up good. Largely because the supply chain was intact. We're getting food complement from Burkina Faso, Niger, and the rest of them. And therefore we celebrated low inflation and all of that. Then COVID came and we became exposed. In fact, COVID was the real test of our performance. We should celebrate it because it actually revealed...
We should celebrate COVID. Something that destroyed us.
No, look, because it actually revealed the propaganda economy from the real economy. And you will see countries that went into COVID with better economic fundamentals. So if your economy was resilient, inclusive, the COVID, they were able to respond relatively better compared to other countries and all of that. Then again, you want to look at the inflows. But you see, in 2017, we had a similar discussion when there was a change in government. The base pay increase was at, I think, 12.5% or so. And all of that. If you look at the discussions that went into that also, you will see the goodwill of the government.
12.5.
Yeah, and how organized labor was very accommodative and all of that. But let's not take that for granted. As I indicated, this is the honeymoon, and the NDC is enjoying that honeymoon effect and all of that. I'm just hoping that they will take practical steps. Their first major budget, we are told, will be presented on March 11th and all of that. I think that is very important. We need to rally Ghanaians behind. We need to increase productivity. We need to also improve spending efficiency. There was something the president spoke about. I think the Minister of Finance during the vetting also mentioned that they will have a committee that will look at value for money in terms of big ticket procurement, so that we don't spend so much to get so little and all of that. I think if we could look at that progressively, Ghana will be making progress. I think those are the things that
I see. So, what should we be doing? I mean, looking forward. I mean, the 10% is not good enough. They say it's the economy and all of that. What should we be doing to improve the economy? You talk about food inflation, to bring that down, to ensure that inflation itself comes down, and that ultimately will affect growth, and that may even help the exchange rate. interest rates may come down. What should we be doing?
Yeah, thank you. I mean, if you look at the space that we have, now we have the medium-term growth strategy, which has put together what the country could do to improve its revenue, as we have it now, from 13.6% of GDP to the 18 to 20%, what we should do. So if I look at that document, I feel now what is scaring at the face of the NDC is the fact that certain pronouncements that were made, especially with taxation, probably is coming back to hand them so quickly.
The scrapping of the taxes.
Yes.
But they've committed to that. The finance minister.
That's what I'm saying.
Said it
so if you look at the medium-term strategy to move revenue, and in the continent, we are about the 38th or so.
With a very low tax to GDP
revenue
ratio.
to GDP. So this medium-term strategy to improve revenue to about 18 to 20%. That included some of these COVID tax, it included e-levy and all that. So now if you come up with pronouncements of abolishing certain taxes, then you will meet the reality earlier than you thought.
I think his point really was that not everybody pays tax, so his would be to expand the tax net and ensure compliance.
I get it, I get it, and I mean I agree. I agree with you that I mean in the informal sector, as we say, even the PAYE versus the informal sector, the ratio is 13:1 in terms of revenue. So we need to expand it. We need to be efficient with it. But what I'm saying is, if you look at the medium-term strategy to improve revenue, okay, I feel now the reality is dawning in. Taxes are, the things you don't just go in, and we seem to be sometimes playing, unfortunately, to a certain tune, okay? Because, see, before you make pronouncements on taxes during campaigns and all those, you must be really careful. You have to look at the forecast, you have to look at projections into the future about certain sectors, about the economy as a whole.
But they said they've done all of that.
I'm coming.
Yeah, but I'm also promising.
I'm London. You have to look at certain sectors, the economy as a whole. Whether you're going to see growth in the sector, whether there's going to be whatever level of growth in the economy itself, because if you're going to meet this medium-term strategy, revenue strategy, as I'm talking about, and at the same time, I'm not saying make life in quote easy for, the populace, don't abolish certain taxes, but then if you have a strategy to follow to improve revenue, but at the same time you are abolishing, claiming to, indicating that you are going to abolish certain taxes, then you have to be careful. You find yourself in this tight corner that now that you are giving, increases that are really, really below where even inflation is. And the real increase is actually negative. The real increase is actually negative.
But as I said earlier, it's been so for a while. Yeah, it's been negative for a while.
But by what gap?
So if inflation was like 30 or even 50, and then you give an increment of 20.
Now I'm talking about, look at 2024, 2023. Look at the gap. So the real increase, the negative gap, now is so wide. It's so wide. That's what I'm talking about. So if you play to a certain tune and start making pronouncements about, tax cuts and so on and so forth, then you have to be careful, because projections and forecasts should be guiding you in terms of making these pronouncements.
Very well.
If a sector or the entire economy is not going to grow to a certain extent.
But you see, we don't know that for now, because they are yet to deliver their first budget. So they may abolish those taxes and maybe introduce other things that will raking the revenue.
It's even look at the whole thing one-sided.
Raking the revenue.
When you have
so
taxes,
maybe it's after the period, maybe after the year, or when how this works, that a lot of the things you're saying.
Actually, we have our own record. In 2017, the MPP abolished many more.
Yeah, they called them nuisance taxes at the time.
We are talking about it. And actually, revenue went up by more than 16%. And
because those taxes were abolished.
Where some of the rates were adjusted, and then they brought in some of the compliance measures and additional. So we ended up with tax to GDP ratio that went up slightly, and revenue itself, compared to 2016, actually went up.
I see.
And so
I want to move to DDBEP. Just 3 minutes.
Why we came to where we were, where the indiscipline, fiscal indiscipline that the government exhibited. There's no point in raising taxes and wasting the taxes on nothing. That's the problem. So if you say you are reducing taxes,
but a lot of the money was used on some social things.
For the
free SHS.
We just use all these free SHS. Look at how much has been spent on free strongly
spent over 9 billion. You know,
on what they said was 5.7 million students. When the actual figure
so 10 billion, around 10 billion on 3.1 million or 3.17 million students,
and they gave us to justify the 10 million.
They said 5.7 million. But that record
that is not a
that record.
And then look at the banking sector cleanup.
Yes.
Do you know that up to now we have 3 different figures being bundled around?
So we expect the finance minister to now put out the figure.
Yes.
So now let's look at DDP. Let's do some 2 minutes on this. There has been some banter on this, and the sinking fund, the sinking fund, that the sinking fund is now working. The debt service reserve account, there's now money getting in there. That is what we're using to settle the DDEP and all of that. The MPP strongly came out to say no. It's because we left the buffers. NDC, through Felix Ofosu-Kwakye, says no, there were no buffers. And he referenced the sinking fund that, you know, the last time there was some movement in it was around October, and it was just some $64,000 in there. And as of 31st January, 96 million have been transferred in there, clearly showing that, you know, the sinking fund has now been operationalized. And that is the reason why things are getting better. And he even says that some 96 million or some huge amount of money is 9 billion cedis has since been put in there for the next payment in July as a buffer. You know, the question is, what has the NDC done in the last few weeks to claim that all these monies that have been taken from other places into the sinking fund is as a result of your work? But nothing really has happened yet.
Reordering business. Reordering business of government. Cutting out waste and wastage. Ensuring that what monies are for, what monies come into the kitty are properly prioritized.
That's what been done quickly then.
Yes, but what the government is about thinking out of the box.
Well done. Is it 6 weeks? How many weeks now?
It's less than 2 months.
Less than 2 months. But government is about thinking out of the box.
Well done.
Yes, government is about thinking out of the box.
Let me tell you, these within 6 weeks.
Yes.
No, we didn't create them. When the inflows are.
So the inflows are always coming.
The inflows are always coming. The taxes are always coming. Okay, but if you decide that you want to engage in wastage, profligacy, and then you don't service your loans, you have a problem. So we are saying, and then we knew, to be honest with you, probably you don't credit NDC with any intelligence, modicum of intelligence. I'm telling that we knew that upon assuming office, the first few months upon assuming office, we will have to service loans. And that we knew. And then, Setekwe, in the discussions I attended, always said that, look, the first thing NDC will have to do if you want to have the confidence of the international community is to deal with the debts. And that wherever we're going to get money, if it meant reordering our things, we had to do it. So we knew, we were not just,
is a different part of our economy not going to suffer because we've reordered business?
Oh, you are looking at impact effect. Impact effect. So to reorder business is to take where the impact will be lesser, channel it to solve a problem which impact will be greater and disastrous for the country. And that's what we have simply done. It's not that money doesn't come, no. Money came.
So you reordered business.
Look,
wow.
The money came in.
If he's talking, we should listen to him.
Money came in.
Well done.
Yeah.
For 6 weeks,
yes. So,
creating this magic.
Yes. Okay, let me come to you first. So 6 weeks. I mean, they've reordered business, and things are happening.
And the results are showing.
Yes, and there's some buffer already, 9 billion already waiting for. So that's recent. I mean, there's some 9 billion already waiting for July, August. That's quite impressive, you know.
Yeah. I mean, if you look at it, you ask yourself, within this short window, really, what has been done differently to try to claim some glory for servicing debt that had been structured already, debt that was scheduled properly, and the NPP government had paid on 3 occasions. There hasn't been any default whatsoever. So the fourth one, funds had been earmarked for it to pay in the sinking fund. I mean, now, I'm coming. I mean, there's been, this information that there was a certain amount that was far below. Fine, even if the figure there was far below, whatever, I'm coming, whatever it was, I mean, I don't have the figure now. Whatever it is, definitely it was due to sweeping of funds from other accounts with buffers to consolidate.
So that's
to be able to be. I'm coming. Let me finish. Yes. To be able to service, even if they're claiming the sinking fund was not well funded. Okay, but those buffers in the other accounts, I mean, who left them there? Why, if the so-called economy being criminally managed or whatever, why were buffers left to be swept into this sinking fund or debt service account?
There were no buffers there were no buffers. So money is constantly coming in, and so they just, like you said, just reordered the business. So let's say if you were spending maybe 10 cedis on maybe free SHS, this time around spend maybe 5 cedis, bring that 5 cedis, take it here. You know, that kind of thing. They talk about impact effect.
That is interesting. We're talking about 6 billion cedis here. 6 billion. So the 6 billion within a window of 6 weeks. I mean, Ghanaians are watching and listening within 6 weeks. So you're telling me the tax revenue that came in. Look at the annual tax revenue and prorate it, and look at the period of 6 weeks. If you're going together, even if you gather from other areas. So we need to be careful on certain pronouncements.
So it would have been better if they said that they added to efforts of the past regime to make this.
Of course, I mean, they're definitely sweeping from other accounts buffers there, and if they possibly did a bit from the securities market through auctions and whatever, they have to say it. But making it look so clean and actually, why should you take glory for a scheduled payment? Government is a continuum. So scheduled payment, fourth payment, it had been planned and prepared for.
Very well.
And first 3 had been paid. So
the last 2 minutes,
why should we take glory for paying something that was scheduled and prepared for?
Very well. Prof, who should be taking? Is there any glory at all to be taking?
Maybe Parliament should come out with a formula so they can use to share the glory. Yeah. So I want to lean on what he just said, that it's not like it just started. There's a memorandum of understanding, there's a payment schedule, and all of that. I think what is good for Ghana is the fact that the new government is respecting that schedule and has also indicated strongly. You know, if you look at our public finance space, there are certain ways that when you mention, some names come to mind. Sinking fund. Okay, so with these guys in charge, I believe that the signal to the market is that there should be no perceived default under this arrangement. And I think it was also smart the government did so, because you need to consolidate the goodwill, the confidence. So if you check in the run-up to the 2024 election, government was struggling to even meet its auction target in the money market. We couldn't meet our treasury bill target. November, we struggled. But you could see that right after the election, like some immediate confidence, like some kind of deposit of trust put in the government account, and it showed up in the treasury bill sometimes more than 40% oversubscribed.
Government are rejecting the bid.
But all of that is at the short end of the yield curve. What the government actually needs is to be able to operate in the medium to the long-term end of the yield curve. And I believe that this announcement of the sinking fund being operationalized and all of that will help us to reopen the bond market. Before we can go to the international capital market, let's begin to trade in our own bond market. So I think I congratulate the government for keeping up to the arrangement. And of course, the previous government had also kept to that. So before you talk about fourth payment, fifth payment, there was first, there was second, there was third. Okay, so I think now I'm balanced.
You displayed the glory. All right, thanks so much. So in the studio is Honorable Yinsa Fuseni, former MP Tamale Central, the Honorable Twinibu Afoko MP Maso Kwanta, Professor Godfred Alufa Bokwin, economist, University of Ghana. Thanks so much for coming, and we appreciate your expertise. Thanks so much for doing the listening and the viewing as well. My name is Selorm Adonoo. Have a good afternoon.